conference organized to celebrate the 75th anniversary of the adoption of the Convention on the Prevention and Punishment of Genocide. I would like to give a very warm welcome to our foreign guests who will be attending this conference both live and remotely. I would like to give a very warm welcome to Professor David Katin, a New York University professor and a member of the Supervisory Board of the Global Institute for the Prevention of Aggression. I would like to welcome Dr. Yuri Belousov, who is the head of the War Crimes Department in Ukraine's Prosecutor General's office. I would like to welcome the head of Kharkiv Human Rights Protection Group, Mr. Yevgen Zakharov. A very warm welcome to you. I would like to welcome participants and speakers who will be joining us online via Zoom. Dr. Matthew Gillett, a professor of the University of Essex, United Nations Special Mandate holder, Vice Chair of Working Group on Arbitrary Detention. I would like to welcome Dr. Deborah Ruiz-Verduzco, the Director of the Trust Fund for Victims of the ICC in The Hague, Mr. Dr. Anton Korynewicz, a representative of the Ministry of Foreign Affairs, an ambassador at large who will be joining us online, Professor Katarzyna Celińska of John Jay College of Criminal Justice, the City University of New York, Dr. Ludmila Dubczak, a Kiev University researcher, now an associate of the Center for Criminal Justice Studies at Warsaw University. A very warm welcome to the Dean of the Warsaw District Bar Council, Mikołaj Pietrzak, who is also joining us today, and Professor Wiliński of Poznań University, a Supreme Court judge. This conference was supposed to be attended by Professor Adam Bodnar, but as we all know, he is currently the new Minister of Justice. He has new responsibilities. He has been recently appointed to this position, and Maria Eichhardt, who was appointed the Deputy Minister of Justice, was supposed to be joining us, but because of new responsibilities, they are unable to do so. A very warm welcome to representatives of NGOs who are taking part in this conference, the Helsinki Human Rights Foundation, Professor Hoda Association. Those organizations have been cooperating with our chair for a long time. A very warm welcome to representatives of the Polish Judges Association, Justitia. And I would like to give you a very warm welcome from Professor Rzepliński, who is the head of the Programming Council of the Center for International Crimes Investigation, which is co-organizing this conference. Due to his illness, he is unable to join us today. And a very warm welcome from Dr. Katarzyna Witkowska-Rozpara, who is also a co-organizer of this conference. She has COVID and she is unable to join us today. Today's conference has been organized by the Center for International Criminal Investigation, the Center for Criminal Justice Studies, the Institute of Social Prevention and Resocialization, the Faculty of Applied Social Sciences and Resocialization of Warsaw University. Our partners include the Sunflower Foundation. This is a foundation which is promoting international criminal law and plays a pivotal role related to collating information that may be used in the future as evidence in cases related to war crimes committed by Russians in Ukraine. Another partner is the International Association of Penal Law, the Polish AIDP section, and Prawo Justice, a EU project. Dr. Anna Galland is also joining us today during this conference. We also have with us today Kraków Human Rights Group. Its director is in this very room today. Right now, I would like to give the floor to the Dean of the Faculty of Applied Social Sciences and Resocialization. Ladies and gentlemen, usually when I open a conference, I say that I have the pleasure, that it's an honor and pleasure, and I congratulate the organizers. And in this case, I can hardly say it's pleasure to open this conference, but I can definitely say that it's an important topic, and I'm very proud that the Center for International Criminal Investigations has been established at my faculty, that my institute is addressing this topic, that organizers have put so much effort to make this conference a reality, to get you here, to bring you here in such great numbers, and to persuade other important guests to join us online and contribute their knowledge and expertise. I don't have to persuade you how important it is for this conference to be organized. Someone had to address this challenging topic. A legal and social analysis of international crimes in the context of developments which are unfolding beyond our eastern border. And sometimes we tend to forget that crimes may be committed unexpectedly. We forgot too fast about developments that happened several decades ago. We believe that we changed as humankind. It's rather a question than a statement. Have we changed, or are we the same? Or perhaps some people have failed to change and some are changing. I don't know. I don't know if we are able to answer this question, but I do know that it needs to be discussed. I would like to thank you for addressing this topic. I'm a sociologist. I teach classic sociological theories. When I teach about Dernheim, I say that criminal law used to be important in the past, but other types of law are more prominent right now. He said it more than 100 years ago, and when I started working at my faculty, I knew he wasn't right, and I know it for sure today. I wish to you a very fruitful discussion. I would like to thank the organizers for addressing this vital topic, especially that this year we are celebrating an anniversary of the Convention of the Prevention and Punishment of Genocide, and today's debate will be celebrating it again, showing how important it is. So congratulations, and I wish you a very fruitful discussion. I will have to leave because I'm opening another conference in another half an hour. So this shows how active my faculty and this university is. Thank you very much. Thank you very much, Madam Dean. And right now, I would like to give the floor to Tomasz Kazimierczak, the director of the Institute of Social Prevention and Resocialization. Dear guests, dear organizers, there is something about it. When I was thinking, what should I say while opening this conference, what sprang to my mind are exactly those two statements we've heard a minute ago from Professor Gawkowska. Because this is what I feel. I feel happy and I have satisfaction that we are addressing such vital topic at my institute, and I would like to thank you for this initiative, for the effort put in organizing this conference, because we had very little time. And on the other hand, there is sadness in me, because for many years, throughout my life, basically, I had a sense that in this part of Europe, there won't be another war. I'm not a member of the war generation. I was born a decade after the end of the war, but I have a sense that throughout my life, I had a sense, I was convinced that the war is the worst thing that can happen to us, and I had hoped that this lesson has been learned, that at least in this part of Europe, which shed so much blood in the past century and in earlier centuries, that there will be no more wars, but I was wrong. And there are countries in Europe with a turbulent past, but right now they have reconciled and they have very friendly relationships. So there is hope, there is still hope. And I deeply believe that when Ukraine will join the EU, because it is beyond doubt for me that this initiative, masterminded by Schuman many years ago, that united Europe, which is able to reach an agreement, which is able to collaborate, that this is the concept which should guarantee, which is guaranteeing peace among members of the EU, and hopefully this European family will be soon joined by Ukraine and possibly one day also by Russia, if I may have such hope, although we do know how challenging it is and how unrealistic it is right now. So I do apologize for this prophecy, for looking into the future, but I'm looking for hope, I'm looking for opportunities. I hope there will come a moment in time when such conferences will be historical conferences, and this is what I wish to all of you. Thank you very much, Professor. And right now, Professor Beata Gruszczyńska, who is the head of the Programming Council at the Center for Criminal Justice Studies. Ladies and gentlemen, I'm very happy that we have come together, but this is not a pleasant occasion because we are all experiencing massive suffering of Ukrainians and Poles, who are doing our best to help, but we know that sometimes it's not very effective. We need to stay positive, and this conference, organized by Dr. Andrzej Kosiło and Dr. Barbara Błońska of the Center for International Criminal Investigations and the Center for Criminal Justice Studies, headed by Katarzyna Witkowska-Rozpara, who is unable to attend, but we are sending greetings to her. Thanks to them, we can come together, discuss, and communicate key messages to us, to people who are deeply experiencing this tragedy, and to Ukraine. The Center for Criminal Justice Studies was established at the Institute of Social Prevention and Resocialization at the Faculty of Applied Social Sciences and Resocialization. I would like to thank Madam Dean for supporting us. Thanks to her, we can conduct our research and take part in vital initiatives. As a center, we have a broad range of activities. We are involving students. Some of them are very interested in criminal studies. For example, some of them, when they start studying at the Institute of Social Prevention and Resocialization, at the chair of Criminology, they know little about it, but later they start taking interest in this area. So we are conducting research, and we liaison, we have contacts with different centers and universities, and thanks to Professor Katarzyna Celińska of John Jay College of Criminal Justice of the University of New York, we are working on a joint project which is addressing a very important topic: reactions of NGOs to crisis situations related to the influx of Ukrainian refugees to Poland. We know that we in Poland, we are committed to providing relief to address the crisis in Ukraine, but we also know that state institutions have reacted at very different points in time to the crisis, and with varied effectiveness, while NGOs have actually stood up and delivered. This topic will be addressed in the fourth panel by Professor Katarzyna Celińska of John Jay College of Criminal Justice, and we hope that we will have this topic covered by Katarzyna Witkowska, who will be joining us online. So I would like to thank you for attending this sad part of the conference, because it's been very painful for all of us, and I hope that this situation will be resolved soon, and we need to provide assistance, and we are doing our best to be prepared for that. Thank you very much.
Dziękuję bardzo, pani profesor. Teraz zaczynamy nasz pierwszy panel konferencji.
Thank you very much, Madam Professor. We are starting the first panel of today's conference about international criminal justice. It will be moderated by Professor... I forgot. Hanna Kuczyńska, of the Polish Academy of Sciences. Hanna Kuczyńska is also the secretary of the Polish AIDP section and a member of the board of Sunflower Foundation, which is co-organizer of today's conference. So I would like to invite Professor Katina, Yuri Bielousov, and Evgeny Zakharov, speakers.
Good morning, everybody. Thank you. Let me begin with our first panel on the problems of international criminal law. Welcome to Warsaw, and let me introduce our distinguished speakers that will be presenting their papers today in the morning. As the first, we will be listening to Professor David Donat-Katin, professor at the Center for Global Affairs at the New York University, member of the Control Council at the Global Institute for the Prevention of Aggression. Professor Katin will be speaking about the ICC investigations and prosecutions on international crimes perpetrated in the framework of the war of aggression in and against Ukraine, and the urgent need, and so on. So Professor, I think we have 20 minutes for every presentation, because we would like to leave some time for the questions from our audience. So the floor is yours.
Thank you very much, Professor, and I'm really grateful to the University of Warsaw for having put together so many institutions within the university, thanks to the leadership of Professor Andriy Kozilo, that I really thank, and all the authorities present today, as well as the 4 co-sponsors, the International Association of Penal Law, you're also represented by Judge Pavel Wilinski, and the Sunflowers Foundation, Pravo Justice, and the Kharkiv Center for the Protection of Human Rights. I was invited to come here online initially, and I said, well, I've done so many online connections with Ukraine and with Poland that I think the time has come to be there in person. I will try to bring about a vision of the situation under international law, then look into the international criminal law implications, the role of the ICC, and then the loophole that we have on the crime of aggression, which I would have hoped to present to the attention of the new Minister of Justice, if I'm not incorrect, and I think Andriy already knew who he was supposed to have been even before the new government was formed. But I will ask you to go to your minister and tell him, wake up, we need to change the Rome Statute so that the crime of aggression is fully prosecutable as the other core crimes under international law within the only permanent court that has been established by the international community after 75 years that the Genocide Convention was adopted in 1948. My main focus, therefore, will be on the crime of aggression, but I will not omit reference to the other crimes and the work of the ICC in general. In doing so, I need to tell you, I will be very political. And I hope that my distinguished colleagues and friends from Ukraine, if they disagree, they will be able to tell us very frankly, because I think this is an academic institution, and we owe it to ourselves to be frank and honest and tell what we have in our mind, and not to refrain from eventual criticism of a situation that is not ideal as of today. Of course, what we are facing is a shocking reality. On the 24th of February 2022, without mentioning the 10 years of illegal annexation of Crimea and the ongoing war in Donbass, on 24 February 2022, the Russian Federation decided to launch a fully fledged invasion to topple the regime in Kiev, remove President Zelensky and his cabinet, and put some puppet government a la Afghanistan 1980, who then applauded the Russian liberators, would have created a new situation in which all Ukrainians, brothers and sisters, would have embraced again Great Mother Russia. All these with the sponsorship of the Patriarch of the Russian Orthodox Church, who appeal to the Russian youth to die at war so that they can go to paradise. A statement that reminds me the one of Mr. al-Baghdadi, the leader of the ISIS, when he said that every good Muslim should die for the cause of the caliphate so that they will go to paradise. This is what we are facing in the year 2023. Since these days, since what happened, my personal priority was to let Mr. Karim Khan, the prosecutor of the International Criminal Court, know that if there is one person to be investigated and prosecuted for the commission of international crimes, if and when committed in Ukraine, should have been Mr. Vladimir Putin, the president of the Russian Federation, who took the decision to launch an unlawful war of aggression in 2022. Now, what happens under international law, public international law, not yet criminal law or criminal sciences, criminology, when there is a war of aggression? We have one president. Let me talk to you about the law as it is practiced after 1989. As you all know, everything changed in 1989. I was remembering a time, the first time in my life when I came to Poland. It was in the spring of the year 1990, upon invitation of the European Law Students Association at the Jagiellona University in Krakow, to attend a seminar called A Revolution Without a Revolution. All the legislative changes that Poland was undertaking after the end of communism. And I would have thought that that change would have been irreversible. And in fact, to a certain extent, it is. Poland is a member of the European Union, and everything has changed since then. But what has not changed is the idea that war can resolve international disputes, even disputes that did not exist and are fabricated by leaders for the purpose of concentrating on themselves power and what I would call abuse of power. When in 1990, at the end of that year, the leader or the dictator of Iraq decided to invade Kuwait and annex it, the entire international community invoked Article 51 of the United Nations Charter, which defines that there is a right of inherent individual and collective self-defense that every member of the international community can exercise to liberate territories that have been unlawfully occupied by an invading power. We created a coalition. We even allowed the Security Council to exercise its functions as a representative under the UN Charter of the international community as a whole, to trigger the system of collective security under Chapter 7 of the UN Charter, which bypasses national sovereignty, but in the name of the customary international principle embedded in Article 51 of the UN Charter, we all supported Kuwait to liberate its territories from the aggressor state, Iraq. And through a number of measures, including a ultimatum and then a coalition of forces led by the United States, Kuwait was liberated in 1991. Is this happening in Ukraine? Ladies and gentlemen, it is not happening. We are not intervening in support of Ukraine. We are not applying international law as it was negotiated, adopted, and crystallized in 1945 in the United Nations Charter. Why are we not able to do so, or we are not willing to do so? You know the answer. Because it's the Russian Federation who is the invading state. The international legal framework, as set up after World War II, created a two-tier of states. The vast majority of sovereign states, who are the main actors and subjects of international law, and 5 victorious powers who have been given, who are more equal than the others, and have been given a right to veto every decision in the supreme body that decides whether executive action is allowable or not, namely the Security Council of the United Nations. One of the P5, the permanent five, is the Russian Federation. So the Russian Federation on one side was able to veto every decision making within the Council, and it did so. Was it necessary for us to intervene to help Ukraine to resort to the UN Security Council? It wasn't. We could have done so under Article 51 and the law on self-defense, but we decided not to do so. And I'm talking here as a citizen, an Italian citizen, member of NATO. And we did so for another reason, because the P5 under international law, they also have a right, under another relevant treaty, which I will not mention, to detain nuclear weapons. So in the name of preventing a nuclear war, we did not intervene in Ukraine. So it is up now to our Ukrainian friends here to defend their own country until they possibly can, to liberate their territories from the occupying illegal aggressors. Therefore, there should be no limit to the support that our free society should provide to Ukraine. Having made this political and legal caveat, let me go in the merits of my topic, which is what is the role of the international. So, because we cannot forget the bigger issues. Sometimes we forget. We think that what is being done for Ukraine is too much. No, it's too little. What is being done for Ukraine is too little. We did much more for Kuwait, okay, which we love Kuwait. It's a free nation. They are equal to all. Every state is equal to the other. The principle of equality of states is the fundamental principle of public international law, as the principle of equality of all individuals is the principle that is the basis of every legal system, constitutional law, penal law, civil law, you name it. So what do we do to remedy the wrongdoing committed by the Russian Federation as a state and by the individuals who are individually liable for triggering this illegal war? We should apply the treaty that replaces the Nuremberg principles, that make them alive, that codify customary international criminal law, which is called the Rome Statute of the International Criminal Court of 17 July 1998 as amended. And here is the problem. It was amended in the year 2010 in Kampala, where a review conference included the definition of the crime of aggression that was not accomplished in Rome 1998 for a number of historic reasons. The main one was that when the Security Council created two ad hoc tribunals for the former Yugoslavia and for Rwanda in 1993-1994, the international community was facing what they were perceived to be non-international armed conflict. And in non-international armed conflict, you only have 3 of the 4 core crimes under international law being committed, namely war crimes during a civil war, crimes against humanity which are delinked from the war. They are directed against any civilian population, and they are characterized by a widespread or systematic attack directed against the civilian population, or the crime of genocide, which is characterized by the special intent of the perpetrator to destroy as a whole or in part a group targeted as such due to its ethnic, racial, national, or religious identity. All right? Again, delinked from the war. But the idea in 93 and 94 was, well, international wars, wars of aggression, a remnant of the past, something not to think about anymore. Am I correct? Some of you says no. I see a gentleman saying no. But that was the idea. We need to have an ad hoc tribunal only for those situations. Those situations do not encompass aggression. When we arrived in Rome in 1998, let's say that some major powers, especially the United States of America, didn't want the crime of aggression defined on account of the fact that in 1998 we had only one global superpower, and they thought it may be necessary sometimes to use force against the law of nations, against international law. So let's leave us a margin of appreciation. Was it a right decision at that time? I would say it wasn't a right decision. But it was the compromise, and you know, the Germans, inter alia, were the strongest advocates for the crime of aggression to be listed in Article 5 of the Rome Statute. As a compromise, let's include the jurisdiction of the court on crime of aggression, or crimes against the peace in the Nuremberg language, and let's have a review conference 7 years after the entry into force to agree on a definition and on the conditions for the exercise of the jurisdiction of the court. This conference took place in Kampala and made a major mistake. While it achieved a significant progress on the definition, Article 8 bis, it achieved a significant jurisdictional advancement by delinking Article 39 of the UN Charter, whereby it's the United Nations, the body that must make a determination whether aggression or a breach of the peace or a threat to the peace exists in a concrete situation before triggering the powers of the United Nations under Chapter 7 of the Charter. Okay, that's an exclusive power of the Council, not to be confused with the primary responsibility to restore international peace and security, which is not exclusive, so there is a residual power for the General Assembly. That power was delinked, was seen as procedural, and was delinked from the independent exercise of jurisdiction of a court that will only be competent to ascertain the individual criminal responsibility of those who are suspects of having committed aggression. So the court has maintained its independence, does not depend on a Security Council determination. So two important progresses, but one major step back, and it is the jurisdictional regime that we find in Article 15 bis of the Rome Statute. Article 15 bis includes at paragraph 5 a fully fledged exemption for nationals of non-state parties to the Rome Statute regarding the crime of aggression. The Obama administration had rejoined the club of nations supporting the ICC while not ratifying it. They were present in Kampala after 8 years of the George W. Bush administration that launched a war against the ICC, which failed, because the ICC is alive and kicking. It has 124 member states, with Armenia joining in January. Regretfully, they lost the war in Nagorno-Karabakh to decide to join, which is regretful. Sometimes states take the decision only after they lose an armed conflict before they join a major international treaty, and this is wrong. Because, of course, it's a preventative role that we want to make sure it helps us in social science, in criminology, in all the work we do between the law and the society. We want the law to prevent crimes, not to just react to crimes, if I'm not incorrect. But the Obama administration requested that US nationals would be exempted from the jurisdiction of the ICC. Who is benefiting from that request that the other member states accepted? Regretfully, Mr. Putin. So as of today, thanks to this paragraph 5, combined with paragraph 4, which creates an even more incredible exemption, I will explain it to you now, the Russian leadership is exempted from the jurisdiction of the ICC for the crime within which all the other crimes are committed. Let's take Mariupol. What happened in Mariupol? War crimes? Certainly, directly targeted civilian objects. Crimes against humanity of extermination, exterminating entire populations in civilian buildings? Certainly. Genocide, I don't know. You will tell me whether there is a special intent to destroy the Ukrainian population, but probably the siege of Mariupol is the closest situation of mass atrocity that we can find in Ukraine that resemble and bring us to a genocidal intent, okay? But nothing would have happened in Mariupol without the decision to launch the war of aggression, which was supposed to be a clean change of regime that failed because of the resistance posed by the Ukrainian people and government against the invaders. So what has this brought about? It brought about the quest by President Zelensky to create a new Nuremberg, to have a special tribunal. And jurists like me, who have fought their entire life for an international criminal jurisdiction that would be permanent and forward-looking, remained a bit speechless and said, why do we need a special tribunal? What we would need instead would be for Ukraine to accept the jurisdiction of the ICC and immediately propose an amendment to the Article 15 bis, eliminating the exemption of non-state party nationals, as well as eliminating the language of paragraph 4 that has the most incredible norm that you will ever imagine. What does paragraph 4 of Article 15 bis does? It eliminates jurisdiction from the ICC for every crime of aggression in which the army of the aggressor state has not accepted, has not ratified the Kampala Amendment. To cut a long story short, I am Italian, and Italy ratified both the Rome Statute and the Kampala Amendment. But if I would go to Algeria, become the head of the army of Algeria, invade Sicily and occupy it illegally, as an Italian who commit a crime in Italy against my own people and state, I would be exempted from the court jurisdiction under the Rome Statute as amended in 2011. It's what we call a monstrum juridicum. It's unacceptable. If any state, starting with Poland, would propose this amendment to get rid of these norms contained in Article 15 bis, who would object? Who would object? Of course, the Russian Federation would object, but they have no vote in the Assembly of State Parties to the Rome Statute. So this is a reform that needs to be implemented as early as possible. If so, it would automatically re-establish the jurisdiction of the court to the one that already exists if the court would be triggered by a Security Council referral under Article 13b of the Rome Statute, which empowers the Security Council to refer any situation to the jurisdiction of the court for the three core crimes from the entry into force of the Rome Statute, 1st July 2002, and for the crime of aggression from the entry into force triggered by 30 ratifications of the Kampala Amendments, which is the date is 17 July 2018. Therefore, certainly capable of covering the fully fledged invasion that started on the 24th of February 2022. Why is this not yet done? My former organization, Parliamentarians for Global Action, proposed this reform already as early as in March 2022, upon request of members of the European Parliament. There is now a core group led by Germany in New York to draft these amendments. Why have not yet been tabled yet? You should ask your government the question. My answer, so get the Polish government to tell you why it didn't happen yet, and I hope that the new Polish government will take a leadership on this topic. My answer so far has been that we are all victims of this syndrome of extreme cautiousness that is not allowing us to exploit the potential of international law. We are dominated by diplomats who believe in each and every move that we have to do in order to implement and enforce international law effectively will bring about some consequence that God knows what will be happening next. But what can happen worse than what we have seen in the last 3 years? After the total failure of 20 years of war on terror, the Taliban are back in power in Afghanistan as if September 11 didn't happen. Total failure of our American friends and allies and ourselves in this effort to end Al-Qaeda and so on. And look at what's going on with, radical and extremist movements like Hamas, even performing the role of de facto government, like in the Gaza Strip. Number two, we have seen what happened in 2022 with Ukraine. Do we need to wait more? Do we need an invasion of Poland or Lithuania to take a decisive step? Number 3, look at what's going on in the Middle East. The resumption of already existing armed conflict is nothing new, it's something to be expected. We have the necessity to ensure that the international criminal law applies and is enforced. So we don't need to be on the back seat on a diplomatic discourse. We need to be up in front to at least make sure that the law is seen by all and has its own preventative effect. 1 minute, Madam Chair, if you allow me to say very briefly what the ICC has been doing, because I think President Ovmansky told me it's very good that you go to Warsaw so you can tell them what we do. Well, sorry, I've taken the broader view because I thought that being the first speaker needed for you to understand where the approach should be, in my humble view, to the war in and against Ukraine, and what we have not done and what we should do more in and for Ukraine. The ICC has developed a strategy of multi-track investigations. As of today, as far as I understood, there are at least 10 ongoing investigations. One of them has already brought about a prominent case, one that under the principle of complementarity, and we can discuss it maybe in the Q&A, crystal clear could not be prosecuted by Ukraine in the first place because it involves the direct responsibility of the President of the Republic of the Russian Federation and the Air Commissioner for Children's Rights. I'm referring to the arrest warrant of March 2023 against Putin and Belova on the forced deportation of children as a crime against humanity, as well as the forcible transfer of children as a war crime. This is the first time in history that the sitting head of state of a permanent member to the Security Council has ever been indicted before an international criminal tribunal. There is a pending arrest warrant, which is, you may argue, not ideally, but it's at least a measure of justice. It's at least limiting the freedom to travel of the head of state. It's at least staining his global reputation. As you know, in international law and politics, reputation is as important as having a clean legal background. And it is also, most importantly, and let me cite here Judge Ovmansky, having a preventative effect. And why is that? Because some of those children are being returned. The Catholic Church, a number of charities, the Ukrainian government have reported that several hundred children have been given back to their families. Would that happen? Would that have happened in the absence of an arrest warrant? We will never have an answer. Because as lawyers we know, when the law prevents something from not happening, you cannot prove it. But the reality is that this is the defense strategy of Mr. Putin and Mr. Belova. They want to tell us, oh, these children were at risk of being killed during the war. We brought them to Russia into nice summer camps. We gave them to nice families. But now that we can know where to send them back to Kherson or to other places and their family are waiting, we are sending them back. So we didn't have any mens rea to commit any bad crime here. We are innocent. There is a problem, and I finish there. And this is the reason why the prosecutor was so quick in, why is this arrest warrant out, and we don't have yet an arrest warrant for the war crimes in Bucha, which have been very well documented. Maybe because also in Bucha, the Prosecutor General of Ukraine is prosecuting, and they will tell us a lot about it, no? But let me tell you, because Mr. Putin signed into law the Russification of these children. He made a press conference, he made a decree and said, all these young Russians are now back home and we can bring them to our motherland. This is what we call self-incrimination. You don't need witnesses. Is it your signature? Is this your law? Is this what happened? That's it. The case is proven. You don't need to send 100 investigators to find any other evidence. It's a very easy case. Mr. Putin put on prosecutor count table a case ready from 1 to Z. So these speed up the investigation, But the ICC is only one little piece of a much broader picture. Of course, the primary responsibility is for Ukrainian courts to bring about justice for victims, and they are looking at thousands and thousands and thousands of crimes. There is Eurojust with the joint investigative teams in which Poland is member of. There are, under universal jurisdiction, the Ukrainian refugees can bring witness to the crimes that they might have suffered. So under the laws of many states, proceedings may start. And there are a number of other remedies that exist under international law. So let me stop here. I will look forward to receive any question, but let's remember, my final message is as follows. Let's remember that we have to be able in 2023 to apply the laws of 1945, the UN Charter, of 1948 and 49, the Geneva Convention and the Genocide Convention, of 1998, the Rome Statute, of 2010, the amendments to the Rome Statute, and the main missing link, we need to apply a new law which should realign the jurisdiction of the ICC on aggression to the jurisdiction of the other core crimes and harmonize into one regime the law of the ICC concerning the crime of aggression, so that the court can exercise its role, because until the day Mr. Putin and his allies and accomplices, first of all, Patriarch Cyril, in my humble view, until the day they will not be charged for the crime of aggression, I think the measure of justice that we have seen in Ukraine will never be sufficient. Thank you very much.
Thank you very much, Professor Cutting, for this excellent introduction to our today's presentations and discussions. And when you were speaking about the aggression, I think we cannot forget why this aggression wasn't successful, just because of the enormous sacrifice of the Ukrainian people. And I'm sorry that may not be to the topic, but looking through the window, I can't stop thinking about the thing that winter again came and there are people in the trenches. So we are feel comfortable talking and discussing legal issues, whereas this is real, too real for most of the people we are discussing about. Okay, so our next speaker is Dr. Yuri Bielusov, Director of the Department of War Crimes, of Prosecution of War Crimes of the Ukrainian Prosecutor's General Office, and he will be speaking about peculiarities of the national system of Ukraine for prosecution of international crimes. Dr. Bielusov, the floor is yours.
Thank you so much. It's really difficult to talk after such a beautiful, emotional, and charismatic speech of my neighbor. Thank you so much, Professor, for your enormously interesting information. I just was thinking that when I was a student at the law faculty, international humanitarian law was the subject I wasn't interested much, let's say, because I thought, okay, come on, it's a dead law. Why should I focus on that? It's better to study criminal law, criminal procedure law. And last Saturday, it was December 9, and in Lviv, there was a conference devoted to the 75th anniversary of the UN Convention on Genocide. And people also were thinking there that they were never thought that in 75 years after the adoption of the convention, they would talk about that from perspective of practical implication of Genocide Convention in Ukraine. As well as Geneva and Hague conventions, which were adopted more than hundreds of years ago, they are really practical in our nowadays. In Ukraine, so we have, by this morning, we have 113,000 war crimes being registered just for the last 2 years. You all know that the war started 10 years ago in 2014, but just last 2 years, we call it like open invasion, because Russians were hiding 8 years before that they were participating in that war. Now it's obvious for the whole world, and we are facing with all variety of war crimes possible, starting from mass killings tortures, sexual violence cases, deportation of our children, which Professor mentioned, deportation of civilians, kidnapping of civilians and keeping them incommunicado, torture against prisoners of war. Maybe you saw yesterday was a media, very fresh case when the Russian soldiers were staying behind Ukrainian prisoners of war on a battlefield, shooting from their back. It's an example of using a live shield, so-called war crime, which is not a historical perspective, it's what's happening just yesterday. Every day, so they attack, and what you mentioned, the temperature goes down, so we were waiting for that, because last year they started on October 10. When the temperature went down, they started to attack energy infrastructure, which for us, it's a part of genocide, big investigation on the genocide, because it's third basket, as we say, of the genocide is establishing condition for physical destruction. And sure, we all understand that attacking of energy infrastructure during the winter so has a very specific purpose, especially taking into account that they attack not the front line, they attack the whole territory of Ukraine, which is far from the front line. But we also understand as the Ukrainians that it's our homework to investigate this and to prosecute. We don't expect that someone would come to Ukraine and then prosecute all war criminals. We understand that 99% of all crimes would be prosecuted in Ukrainian national courts. Evidence would be collected by Ukrainian investigators and prosecutors. But at the same time, we also understand that these crimes have been called international because of the reason. Because these crimes are so severe that it's not a matter of specific country or two countries. But they call it international crimes because it's a global issue, and the whole democratic world should react on such a crimes. And we really appreciate the whole help being given to Ukraine. We really appreciate the Poland, which was one of the first countries with joint investigation team, and we have a representative here, our Polish colleague, who helped us to collect evidences on these atrocities. We also do cooperate, as Professor mentioned, with ICC, and ICC has the biggest office outside of Hague. It's in Kiev now. We work with these prosecutors and investigators on a daily basis. We also, the specific of Ukrainian context and maybe Ukrainian position, that we want to increase, we call it like umbrella of justice. We want to involve more countries in prosecuting international crimes, because it's not just a matter of ICC. We understand that ICC has a very limited sources, and it's tasked to prosecute individuals we can't do. And we can't do just 3 people. So it's a president of Russian Federation, it's a head of the government, it's a minister of foreign affairs because of the immunities. If we prosecute them, we would violate international law. That's why we need some instances which could do that. And ICC is really one of these. But as Professor mentioned, ICC is limited in prosecuting of a crime of aggression, because a lot of top leaders of Russian Federation didn't commit war crimes. They didn't commit genocide. They didn't commit crimes against humanity. They just signed some documents which made the war happen, like members of the parliament or heads of state institutions which, delivered the army to our borders, or who arranged the funding of Russian army on our territory. That's why we also have a big investigation on crime of aggression. And but again, we need institution which would prosecute top leaders. And there are some discussions whether it should be ICC and some changes to Rome Statute, or whether it should be special tribunal. Ukraine at the moment insisting that it should be special tribunal, which would have international status, because there are some of the discussions about the model. 40 countries at the moment support the idea of special tribunal. They're just arguing with each other how it should look like. Should it be based on Ukrainian legislation? Should it be based on international legislation? Should we have a hybrid model? We don't want hybrid model, because the idea of this tribunal to prosecute leaders which has immunity. We don't want, this tribunal which would say, come on, we will prosecute everyone except of Putin, for example. So this tribunal for Ukraine means nothing. So we want the first leader of the country who made this war possible to be prosecuted, as well as for other crimes, but for crime of aggression also. At the moment, 24 countries in the world started their own investigations of war crimes. And it's a unique situation, because we
coming back to this umbrella of justice, we are talking about the global prosecution. So, because again, just ICC or tribunal wouldn't be enough. 24 countries which started investigations, we coordinate the work with them. Maybe you heard, like several days ago, United States first in their history charged for Russian potential criminals, because they're not prosecuted yet, for war crimes committed in Ukraine. So we're in touch with all these countries because we share evidences, as well as with ICC. We give access to all our cases, we give evidences because we want our international partners to prosecute. We also understand that Ukraine would always be criticized. We are part of the conflict, and our decisions could be subjective. We understand that. That's why the quality of our cases is extremely high, because we understand that the scrutiny which Russians as well as our international partners would pay attention to these cases. What I also wanted to say that at the moment, so we have just a couple of figures from our national justice system. We have 466 suspects. Suspect in Ukrainian legislations mean the person who you officially charged. The person get the official status of suspect. So we have 466 Russians who are being suspect at the moment. We have 300 cases in our national court, and we have already 72 verdicts of our national courts on war crimes. In parallel, we have a very big investigation regarding the top leaders of Russian Federation on the crime of aggression. And there we have more than 600 suspects already. Members of the parliament, people who just signed some documents, whether they, but this signature leads to the fact when the part of the territory of Ukraine became a part of Russia, or when they gave a right to the president of Russian Federation to use the army outside of Russia. Sure, just a signature, but these people should understand that they were part of the system of Russian Federation, which helped to make aggression happen to us. As well as we have a very big investigation on Russian propaganda. And it's extremely, extremely powerful tool. We call it informational aggression, because they, for years before the open invasion, for years before the war, they were working with the mindset of Russians to prepare them to invasion and to support them in its invasion. That's why we have a big investigation on propaganda, which we consider as a tool both for genocide and for aggression as well as economical blocks, so-called. So we have investigations. Just one example against some state companies like railways companies of the Russian Federation, National Railway Company. They just gave carriages to transport tanks to our territory to cross Ukrainian borders. They could say, "Come on, we didn't do any aggression. We just delivered troops to your territory and back. So we just sent tanks to your territory. We don't commit a crime." But from our perspective, they could be these actions could be analyzed as a co-perpetration of the crime of aggression. What we also should say that big challenges, they always open the window for big opportunities, and the issue is to see it. And in the context we have, because adult people don't want to change. They're happy when they're comfortable. They don't want to, to get some new knowledge. Why, if I'm comfortable with what I'm doing? As well as Ukrainian criminal justice system. It's pretty old-fashioned. People get used to some styles of gathering information, collecting this information, storage of this information. And in comfort situation, it's pretty good. But when we are overloading with millions and millions and millions different evidences of war crime, we understood that we will not be able to prosecute and to deliver justice to our people if we will not change ourselves. That's why at the moment we are introducing different digital solutions. We are trying to digitalize volumes of paper documents. We are introducing different databases. We are trying to use different IT solutions which help us to easily identify perpetrator, to make analysis of data we have. And we really, really appreciate the all help we have been given, because our system should be ready not just for acting challenges, but for future challenges. Maybe the last example of such a challenge, 2 days ago, there was a cyber attack to Ukraine, the biggest Ukrainian mobile phone company. It was totally dysfunctional for 2 days. No mobile phones at all. Just a cyber attack. there was no experience in prosecuting cyber attacks as a war crime in the world. Geneva Convention, authors of Geneva Convention, Hague Convention, had no idea what the cyber is because it was 100 years ago. That's why there are some new challenges, but for our perspective, no matter whether the virus was sent or rocket came, so the purpose is the same. That's why we're also trying to together actually with ICC partners, we are considering cyber crimes could be prosecuted as a war crimes. And we work very tightly with our international partners. And we also believe that so these international conflicts we have in Ukraine, which was initiated by Russia and supported by Russia, would also lead to some changes in international law. Because international law is also, from our perspective, should be more flexible and should take into context the current challenges, not the challenges which existed in the first global war. And let me finish with the taking into account that we are in the university, that especially for students present here, that international law is extremely interesting subject. And I didn't underestimate it when I was a student, but I really recommend you to study. We as Ukrainians would be ready to give practical examples how this law could be implicated in Ukrainian context together with our international partners. And thanks so much for Poland for all support to Ukraine, because for us now you are just a window to Europe. Not just window to Europe, you are a window to the rest of the world, because we don't have any other options how to get the support except with your help. Thank you so much for that.
Thank you very much for this very interesting insight into the works and practice of prosecution of international law crimes in Ukraine. Well, we keep our fingers crossed, and we have no doubts that all the necessary fair trial rights are followed in the trials, and that the trials are legitimate in the eyes of the international society. So that's a great achievement, I think, to have fair trials during wartime and with so much going on. So thank you for all the information you gave us. And our next speaker is the president of the Kharkiv Human Rights Protection Group, Mr. Yevgen Zakharov, who will be speaking about the approach of the group to documenting and analyzing international crimes and assisting victims. Mr. Zakharov, please.
Thank you. Our organization has formulated a comprehensive and holistic approach to collecting information about international crimes committed by Russians, documenting and analyzing these crimes, and helping law enforcement agencies investigate these crimes. It also includes rendering legal, psychological, monetary, humanitarian, social, and medical assistance to victims of these crimes, as well as informing Ukrainian and international society about these crimes. The collected information is entered into the database, whereby the event location is recorded. Geodata or addresses of the place crime, the date of the event, the type and description of the event, the object of attacks, and preliminary qualification of the crime under the Rome Statute of the International Criminal Code. Additionally, we enter the personal data of the victims, witnesses, and perpetrators, if they are known, and evidence of the crime in the form of media files, photos, videos, text documents, etc. Many organizations collect this information, including members of the Tribunal for Putin initiative. These NGOs cover the entire territory of the country. Today, the database contains approximately 60,000 incidents of crimes committed by Russians. Based on our research and collected information, we preliminarily classified these atrocities as war crimes, crimes against humanity, and genocide. Source of information for the database are open information on the internet and direct contact with victims and witnesses. Direct contacts make it possible to collect information about, file a report about the crime to law enforcement agencies to investigate it. Therefore, it is essential to find victims of crime and interview them to populate the database, open an investigation, and provide the victim with the necessary assistance. In addition to the work of our reception desk, an important tool of such search is monitoring visits to settlements in the occupied territory, during which our lawyers interview the victims and find out what types of assistance they need. In advance, the local self-government bodies announces the date and time of reception, and its social protection department employees call the victims and invite them to a meeting. The monitoring team includes 2 lawyers who receive people in parallel, and a psychologist who provides rapid psychological assistance. At the same time, the 4th team member makes photo and video recording of the destruction in the settlement for the database. Our team visits the same settlement as many times as necessary to interview all the victims living there. We started such monitoring visits on October 1st last year. For now, we made 170 visits and consulted about 4,000 victims. Following the priorities of the Office of the Prosecutor General, the lawyers of our organization prepared statements of crimes for national law enforcement agencies regarding dead and wounded civilians, illegally deprived of liberty and missing civilians, and prisoners of war and civilian prisoners subjected to torture in captivity and then released. As of December 1, 2023, we consider 1,300 criminal proceedings in which the lawyers of our organization represent the victims, including cases of 247 missing persons, 158 tortured, including 33 cases of sexual violence, 424 killed civilians, 465 wounded civilians. In addition, our lawyers submitted about 4,000 statements about the crime of loss of property. They are registered in the United Register of Pretrial Investigations, but have not yet been investigated. It is very small sources for investigation now, unfortunately. Our lawyers help the police and state security service of Ukraine conduct investigative actions. Such assistance includes questioning victims and witnesses, organizing forensic medical examinations, identity corpses, identifying suspects, etc. In particular, our lawyers identified 9 perpetrators among Russian prisoners of war. We offer victims of crimes comprehensive help. It includes humanitarian assistance, provision of one-time cash support, clothing, medicine, and household items, and so on. Legal assistance, provision of legal advice, reimbursement of attorney's services for representation in national bodies of Ukraine and Russia, international bodies such as the UN Human Rights Committee, the UN Working Group on Arbitrary Detentions, the International Criminal Court, and psychological aid, payment for long-term and short-term psychotherapeutic consultations. Collected information about crimes is summarized in analytical articles and submissions to the prosecutor's office of the International Criminal Court. We have already submitted 5 such submissions. The first and second, in which we qualify the actions of the Russians in Mariupol and the forcibly transferring of children from Ukraine to Russia as genocide. Third and fourth, devoted to illegal deprivation of liberty and extrajudicial executions as crimes against humanity. And fifth, describes shelling of civilian objects and the civilian population as a series of war crimes. Next in line are 2 more submissions regarding enforced disappearances and torture, which we will classify as crimes against humanity. However, it is not enough to transfer this information only to specialists and those investigating crimes, both in our country and abroad. We must reach the mass consumer of information, not only in Ukraine, but also in other countries. That's why we created a special war crimes site in 7 languages: Ukrainian, Russian, English, French, German, Italian, and Spanish. T4PUA.org. We also have the Voices of War project. We interview victims and witnesses of war crimes and other people who have something to say about the war: soldiers, volunteers, psychologists, journalists, artists, and musicians. We already collected about 300 of these interviews on our website and our YouTube channel. They are informative, tell a lot about what is happening in our country, and show the level of mutual assistance and solidarity between Ukrainians. They also demonstrate what kind of terror the Russian military instills in the occupied territories and how brutally they treat peaceful citizens. We translate the best interviews into other languages. Voices of War are now heard in 9 languages, including Polish. Also, we are probably the only organization in Ukraine that regularly publishes information about Russian protests against the war in Ukraine. We have published a weekly digest of such protests since mid-March last year. Finally, I want to stress that the individual components of our approach are very closely related to each other and support each other. We are interested in extending this approach to all 10 Ukrainian regions where fighting occurred. And in the end of my speech, I would like to grateful Dr. Kasper Zayas for his work as volunteer in our analytical work. He was advisor and editor of this for our submissions, and his influence essentially became it better. Thank you for your attention.
Thank you very much, Mr. Zakharov, for giving us the perspective of victims and the efforts of Ukrainian community to document the war crimes and all the violations of law, and your efforts, your real efforts on the ground to help people to bring them justice. We had a chance to, so thank you very much. Thank you, distinguished speakers, for your presentations. Thanks to your presentations, we had a chance to look at the problems of international criminal law from 3 different perspectives. The theory of international criminal law, so from the level of international criminal justice, the perspective of practice of prosecution on the national level of Ukrainian authorities, and the most important, we had a chance to look at the perspective of victims and their search of justice, where we could learn about the problems of documentation of the crimes on the ground. So this way, the speakers presented the full pictures of efforts of the international and Ukrainian community, the prosecutors and judges, NGOs, in preventing impunity and bringing justice to the victims. And now we have 15 minutes for the questions. So I invite the audience to ask questions and participate in the discussion. So are there any questions from the audience, or maybe from the speakers to other speakers who would like to clarify some points?
Zachęcamy Państwa. Słychać? Zachęcamy Państwa do dyskusji. Można też zadawać pytania po polsku, jest tu tłumaczenie. Także czy ktoś z Państwa może chciałby zadać pytanie naszym prelegentom? Bardzo proszę, Panie Profesorze. Pan Profesor Utrat Mielecki-Ipsir.
Thank you. I would like to ask Professor Katin about the crime of aggression. Is it possible to think that it exists under customary law? Because we cannot do lectures on agit. So is it possible now? How it is discussed now? Thank you.
Are we collecting questions, or the speakers would rather answer immediately, like after every question? Yes. So,
yes,
please.
Customary international law is one of the sources of the law, for example, under Article 21, applicable law in the Rome Statute of the ICC. Of course, the moment we have a treaty-based, self-contained system under the Rome Statute, we need to look at the sources of the law, as we do when we apply the law before the International Court of Justice. We look at Article 38, which is the most important article when we teach international law to our students. So under that law, however, it is written that the statute applies in the first place should there be loopholes or missing elements in the normative framework, you resort to applicable treaties and customary international law. Now, the problem is that the Rome Statute has aggression already listed, and then there was a treaty-based definition, which is the one that we have to apply, Article 8 bis. The problem is not of a definition. The definition is there. It eliminates the gray zone, so the illegal use of forces for humanitarian purposes, like in Kosovo, 1999, that's illegal under the UN Charter, it has to be clear, but it's not crime of aggression. So that definition has been drafted in such a way not to cover every possible illegal use of force, but it's a very modest, very close to the Nuremberg definition criminalizing a war of aggression. In Nuremberg, however, it was insufficient under the nullum crimen, nulla pena sine lege principle, because it says a war of aggression is a war of aggression. Am I right? Read it carefully. It doesn't define it. It's too vague. So this one, it contains a list of punishable conduct, like the bombardment of a foreign territory, the invasion, the change of regime, the blockade of ports. There are a number of acts, but they have to be as a very consistent, grave, and manifest violation of the principles and purposes of the UN Charter. So these three elements of gravity are contained in the definition. So we cannot resort to customary international law because we don't need it. We have it. The problem, we have the definition. The problem is the exceptional restrictions to the jurisdiction of the court. So it's about procedural law, not substantive law. That's where we have a loophole. That's where we need an urgent reform to realign, because what is the object and purpose of the treaty? To put an end to impunity for the most serious crimes of international concern to the international community as a whole. The most serious crimes are 4, not 3. So we need to fix this, because what was agreed in 2010 in Article 15 bis, paragraph 4 and 5, is a deviation from the object and the purpose. Once we do that, we can have the jurisdiction of the court realigned from the 17th of July 2018, maybe not covering what had happened in 2014, 15, 16, and 17, but its continued effect from July 2018 in Crimea and the Donbass, as well as what happened in February 2022 and onward. So that would fix the situation, and in my humble view, it wouldn't make necessary for the creation of a special tribunal. Small caveat. Ukraine should ratify the Rome Statute. Because if Ukraine does not become a member of the Rome Statute and accept the jurisdiction on the crime of aggression, we would miss that element of consent. Ukraine could still accept again ad hoc under Article 12, paragraph 3, the jurisdiction of the court, as it did in 2014 and 15 twice. That's fine. But you know, it's like to take the bus without paying the ticket. You still travel, but you're not a full member that has given its contribution, that has a voice. And maybe, I think Ukraine, especially the army of Ukraine here, why they haven't done it if most of the parliamentarians, the human rights NGOs, like the one of the Tribunal for Putin, led by also my dear friend and colleague Alexandra Mantwichuk, and all the other NGOs forming part of the 4 a.m. coalition. Everybody is in favor of ratification. Why Ukraine doesn't ratify? It should have done it under the EU-Ukraine Association Agreement. I think somebody lobbied the chief of the army and the Ministry of Defense, most likely the United States of America under the Trump administration, which ended up even sanctioning prosecutor Bensouda for her investigations on Afghanistan and Palestine. And this is so short-sighted and wrong, because once again, who's benefiting from these attacks against international law carried out by the United States? I teach at NYU, so I tell my students the same things as I say here, I said them in New York, no problem about it. Weakening international law by the United States empower the Russian Federation to break international law even more, with impunity so far. So this should be why we should change the course of action within the ICC, but also within NATO, the United Nations, and all the other bodies in which we participate with our closest allies, the United States.
Dobrze, czy ktoś ma jeszcze jakieś pytanie?
Nikita Grakowicz, Helsinki Foundation for Human Rights. Can I have two questions? One is brief, but probably answer is not that short. To all our distinguished speakers, what is your experience with universal jurisdiction and what are the challenges it poses in our countries? Because there are many from our experience. And the second one is probably more to Yuri Belousov, but obviously for everybody, is the pressure of the judicial system on the survivors. As we all know, probably the judicial system used to be not very pleasant for the survivors. And in this regard, we have, as you said, 113,000 cases. And obviously not all of them are possible to prosecute due to, for example, perpetrators being in absentia and all the other issues. And this term, what are possibilities of rehabilitation to the survivors? And thank you.
So who would like to answer the question as the first? Going from the east, yes.
Thank you so much for your questions, really interesting ones. So regarding the first one, when I mentioned these 24 countries which started their own investigation, some of them started within the national jurisdiction when the citizen somehow was involved in a crime, was as a suspect or as a victim. Some of them within the universal jurisdiction, like Germany, for example. And we are in touch with these countries. It goes pretty well. So we are using the Eurojust instrument. So we coordinate through the prosecutorial offices, let's say. And it's definitely, from our perspective, it's a good way to increase the pressure over the international criminals, not just it's not about the conflict between Russia and Ukraine. It's a signal to all potential aggressors and war criminals that it's better not to commit a crime of such kind because the whole globe would start to react. And that's why I really believe that the perspective of universal jurisdiction, instruments of universal jurisdiction would be fully applicable and would help us significantly. As to the second point, it's absolutely correct questions because pretty often for the criminal justice system, the main focus is under the suspect. Our task is to find, to prosecute. And pretty often victims being considered just a source of information because prosecutors and investigators don't have time, to take care of the victim, which is fortunately changing now, this approach. And this year, within the Office of the Prosecutor General, it's the first time in the history there was established a special coordination center for support of victims and witnesses of war crimes. That it's already people been already selected and trained, and their task is to coordinate the activities of other state and non-state institutions in providing the specific help to a victim based on the specific needs during the investigation. It's also extremely important to train prosecutors and investigators because we interview significantly traumatized people. And if you're not being properly trained, it could lead to second, third, fourth traumatization of the person. Because our task is to get information. For this, we need to put the person in a context when the crime was committed. And when we put it in the middle of trauma, this person. And sure, if you don't know how to deal with that, so we could lead to the traumatization. But there is one more aspect. Prosecutors and investigators have been seriously traumatized with such interviews. And that's another issue. No one talk about that. So it's like robots who should do their work. That's why we also started to work in psychological resilience, support of our investigators and prosecutors who work on the ground. But as to the victims, it's a big shift now in Ukrainian criminal justice system. It takes time, it's a mindset changes. But we really appreciate the whole support we have been given from other countries. And the significant role here is also been performed by our NGOs who first maybe started to work with survivors. We have already even state centers for rehabilitation of victims of war. But, taking into account the scale, and we could say that all Ukrainians are victims of war. It's in a wide perspective. But sure, within that, there are very vulnerabilities which need additional support. And we were discussing, I've been to several meetings in the United States, for example, and we were thinking how to organize this work with our veterans who are coming back with their families, with people who lost their loved ones. It's a huge, huge work, and that's why any help in this sphere also would be more than appreciated. So thanks for the question.
In general, there are many problems regarding this practice. You see, main problem is right to defense. Naturally, Ukrainian lawyers don't want to defend Russian militaries. And in fact, defenders act jointly with the accusation. And it's not a real court in general. And I'm afraid that in future it will be create many problems. 99% of proceedings are in absentia. And again, our judge don't fulfill as a rule necessary actions regarding this status, and again, in the future, in the European Court, there will be problems with these verdicts. And at the end, I would like to notice that, unfortunately, verdict for these crimes are closed in the unique register of court decisions. It is impossible to open register and to read these verdicts. I believe that it is incorrect, absolutely. But what reason, I don't know.
Thank you very much. And Professor Katin, would you like to add something?
Yes.
Okay.
Think,
very good questions.
yeah, this was a very good question. I think, if I can say something here, when you say survivors, you mean those who survived. When we say victims, we say the survivors as well as those who have lost their mother, father, son, and they are also victims, and they have equal rights. So that's why there is a bit, but I just invite you to consider that. Now, let me tell you something. Why is the crime of aggression so important? Because the same Russian soldier who could have committed a war crime in Bucha, he is an alleged perpetrator, innocent until proven guilty beyond reasonable doubt, of course, with the right to defend himself. He's also a victim. A victim of which crime? The crime of aggression. Who is dying every day in the Ukrainian front to save his country and people and perform his duty? He's not a victim of war crime. He's lawfully killed by the Russian soldier under international humanitarian law. International humanitarian law is there to give some limits to the combatants. As long as, however, military necessity is fulfilled, you can kill your enemy. It's your right at war. Yet the Ukrainian soldier who dies is also a victim of an international crime. Again, which crime? The crime of aggression. Why? Because the crime of aggression is a leadership crime. And until and unless you are somebody who can, make a phone call to Mr. Putin and tell him, I want to go, let's invade. If you prove that, which is, I think, impossible. Also, the foot soldier of the Russian side is protected by the crime of aggression. That's why the crime of aggression is so important, because it points out that what we need is law, not war. Law is senseless, is unlawful. War is senseless, is unlawful, and we must replace it with the law. So, in the end of the day, I think universal jurisdiction can help. of course, especially on the other crimes, less on the crime of aggression. What I think is very important, in my humble view, and this is where I disagree with the Ukrainian colleagues here and with other colleagues, it's a minority view mine, I don't think Mr. Putin has any immunity before Ukrainian courts. The problem is how to get the members of the Troika to Ukraine, because their immunity applies to third countries if they would travel before other jurisdictions. Once you have, Adolf Hitler didn't have any immunity when the Allied powers in 1943 decided to establish the Nuremberg Tribunal with those principles. If he would have had immunity, he could have not been brought to Nuremberg if he would have not killed himself. Am I correct? This law is based on the fact that we change the paradigm, and there is something more important than state-to-state sovereign relations, which is to prevent international crimes, which are disrupting these international relations. However, what is very important here is the political perception that justice is done in a fair and impartial way. And they are doing it, in my view. Ukraine is doing everything possible to make it impartial and fair. However, what is the perception in Moscow if a major military man is prosecuted in Kiev? This is Ukraine continuing the war through tribunals against us. That's why international jurisdiction is useful and, I would say, also necessary for the purpose of depoliticizing the perception of justice. Again, justice is already non-political because we have people of the quality of Mr. Belousov. Yes, Yuri. I mean, I'm impressed by his presentation. I would go to trial before him if I wasn't accused. However, the people will not understand, the ordinary people. Instead, if it's a court somewhere else, they will understand better. So that's why my final point is that we need to give more resources to the ICC. The ICC is too small. It has been created to handle a limited number of cases. Not anymore. We need much more. We need to make it happen. We need to give much more investments to this court and make it also have trials in Ukraine when it will be possible. So the court can also sit outside of The Hague and be close to the crime scenes. And many things shall happen and many reforms shall be carried out. And I think we should all be ready to the task.
We are out of time. I will just raise, thanks to Evgeny Zakharov, the issue about the human rights and war. And it's especially for lawyers, it's very, very interesting point. Because to be objective in the war conditions and to protect human rights of the enemy, it's extremely difficult task. Extremely difficult. I would recommend, I think you all have seen, but I really recommend the movie Spy Bridge, if you haven't seen. I recommend especially for students. That's exactly which is relevant to Ukrainian context now. Because when I was started to lead this department in May 2022, the first we said to our prosecutors and investigators all across the country that investigation of war crimes against the enemy should be of a higher quality than the ordinary investigation. And it was difficult to explain, because it's obvious, it's enemy. Why should we waste our resources? Everyone knows that they commit war crimes. But exactly because of the scrutiny and because Ukraine wants to be a member of EU and member of European family, we made our choice. We said that we should focus not on Russian standards, but on standards of the community we want to be a member of. And it's really difficult things. We had several closed meetings, I would tell you now, so with our lawyers, saying, guys, we are prosecutors, we ask you to protect suspects who are Russians. Yes, you are afraid that people will not support you. You are afraid that you would be beaten maybe on the street, but that's your work as a lawyer, to protect no matter who is in front of you, and to protect even the enemy during the war. It's a really difficult issue, and the legislation is not perfect, especially in absentia cases. We'll understand in absentia cases when we don't have a physical presence of the suspect accused. That's why we are trying to design recommendations how to notify the person who is not here, who you don't know even where the person is, about the trial. Fortunately, now there are different technologies, WhatsApp, social networks, and I would finish with a maybe funny story, because when we were charging the members of the parliament of Russian Duma, our guys find the Facebook page and downloaded the charge just under the comment of the member of the parliament. And he wrote it and answered in a very bad way. But we made a screenshot, so he read it. So he knows that he's been charged. That's why even such screenshots we could use in the court, and that we notified the guy, he definitely know. But it's a difficult issue. And it's very important for the lawyer, because we have different roles. We are citizens, our neighbors, our loved ones could be killed, but we are lawyers and we need to be objective, and it's a difficult task. But that's why the lawyer is such a difficult profession. Thank you.
Thank you very much. So we ran out of time, so we have no time for questions, unfortunately, because there is a long day ahead of us and many discussions. Thank you very much for the speakers and for the discussion from the audience. Once again, let's give applause to our speakers.
I will ask the first speaker of our session, of our second session. This is Dr. Matthew Guille. He is a professor of University of Essex. He has a vast experience in dealing with international humanitarian rights violations. He used to work in the ICC. He used to work in the ICTY. He was also a representative. He was also a member of the delegation of New Zealand, who was working on the Convention on Aggression. So he has huge input in this, how this definition of the crime of aggression has been developed. Matthew is also one of the founders of the Project Sunflowers, who is one of the co-organizers of the event today. I hope that everything will go well, smoothly online. Matthew, the floor is yours.
I'll present in a personal capacity today, but drawing on my experience both with the United Nations and with the International Criminal Court. On 22nd February 2022, 2 days before the full-scale Russian invasion of Ukraine, Vladimir Putin gave an hour-long televised address to the Russian nation in which he denied that Ukraine had ever had real statehood. He claimed that Ukraine was instead an integral part of Russia's own history, culture, and spiritual space. He had also written a 5,000 or so word essay a few months earlier along a similar line. Now, his statements, amongst other actions, have been cited by many, including world leaders, as evidence of his genocidal intent. For example, Joseph Biden, President of the United States, said, quote, "Putin is just trying to wipe out the idea of even being able to be Ukrainian." And this prompts the question of whether statements denying statehood are genocidal in nature, and if so, how. Some scholars, such as Apazov et al., in the Journal of International Criminal Justice, have argued that these statements are genocidal in nature. They write, quote, "In Putin's speeches, one can see that his final aim of subduing Ukraine, taking it back under full control of Russia, and then correcting, internal quote, Lenin's mistake, close quote, and depriving Ukraine of any signs of statehood." And based on this, they say it is an integral part of one of the main proofs of genocidal intent of the military and political leadership of the Russian Federation. On the other hand, you have scholars such as Professor Shabas, who's worked on genocide cases at the International Court of Justice, who has argued that, for instance, quote, "The anti-Ukraine campaign in Russia appears to be about defining national identity. This may be incitement, it may even be incitement to violence, but it is manifestly not direct and public incitement to physical destruction and extermination." End quote. Others would argue that statements such as Putin's mentioned relate to the state-to-state crime of aggression and that they're not genocidal in nature. However, what I will seek to present today is that this is a false dichotomy, and in fact, these types of statements can be relevant, can be very forensically relevant when proving genocidal intent. At the same time, they are not exactly equivalent with genocidal intent. They're not sufficient in and of themselves without any further evidence to immediately conclude that there is genocidal intent. What's important here is the way in which the statements are delivered and the context surrounding them. So not every aggressor is a genocidaire, and not every genocidaire is an aggressor. When it comes to prosecuting these cases, the details and the specific evidence matters. So what I'm going to do is survey doctrine, the legal provisions, and then precedents from international courts to look at the precise ways in which denials of statehood can be relevant to proving genocide. I do have a presentation which I will now try and share, and hopefully you will be able to now see this as a full screen. It appears that you are seeing this as a full screen. And here we see, for example, the definition doctrinally of genocide. I've based this on Article 6 of the Rome Statute, but for the intent purpose, it's the same wording as in the Genocide Convention and the Yugoslav Tribunal Statute, for example. Now, it's been argued previously that destruction of a national, racial, religious, or ethnic identity as a social characteristic, rather than physically killing, exterminating the people themselves, but instead the eradication of the abstract entity is equivalent to genocide. So, for example, in 2000, the Federal Constitutional Court in Germany said, quote, "The statutory definition of genocide defends a supra-individual object of legal protection, the social existence of the group. The intent to destroy the group extends beyond physical and biological extermination. The text of the law does not, therefore, require the interpretation that the culprit's intent must be to exterminate physically the targeted group," end quote. Now, from that perspective, if you eradicated the very idea of a state, the idea of a nation, or a race or religion or ethnicity on the same line, then you would have genocidal intent, even if the group continued to live, for example, as a minority in another state. However, that somewhat automatic type of conclusion does not accord with the approach taken in the international courts to date. So, for example, if we look at the International Criminal Tribunal for the former Yugoslavia, which dealt with several genocide cases, several of which were successfully resolved with convictions, but some of which did not, we'll see that the notion of statehood came up frequently in the litigation. And, for example, observers at the time, the UN Protection Force mission, noted that, quote, "The sides to the conflict were locked in a fight to the death over the future shape, character, and even existence of the new state, in that case of Bosnia and Herzegovina." So in that context, the way in which the Yugoslav Tribunal dealt with claims and denials of statehood, especially in the context of genocide, is particularly pertinent, apposite. So if we look at really the lead case on this issue is the Krstić appeal judgment of the Yugoslav Tribunal. And there they focused quite heavily on the biological and material destruction of the targeted groups. So, for example, they said, quote, "An enterprise attacking only the cultural or sociological characteristics of a human group in order to annihilate these elements, which give that group its own identity distinct from the rest of the community, would not fall under the definition of genocide. and they stated that instead, customary international law limits the definition of genocide to those acts seeking the physical or biological destruction of all or part of the group. And that approach was followed in, for instance, the case against Radovan Karadzic, who was the former so-called president of the Republika Srpska, who was charged with and convicted for genocide. Now you see the definition listed there, which I'll place on the slide. Whilst I do, I'll note that the Yugoslav Tribunal's approach, this more strict approach, accords with that taken, for instance, by the International Law Committee in its commentary on the draft code of crimes against peace and security of mankind in 1996, where they said, quote, "The destruction in question is the material destruction of a group, either by physical or by biological means, not the destruction of national, linguistic, religious, cultural, or other identity of a particular group." And you can see that in materials issued at the time of the adoption of the Genocide Convention 75 years ago, as of Sunday, we had the anniversary, of course, that there is, again, this reference to the existence of the group and annihilating the group. So, for instance, UN General Assembly Resolution 96-1 of 1946 talks about the denial of the right of existence, just as homicide is the denial of the right to live of individual human beings. So it's quite a concrete notion rather than an abstract notion as regards what it is to live. And similarly, Raphael Lemkin, the, of course, key proponent behind the adoption of the Genocide Convention as far as individuals went, also referred to genocide in existential terms, albeit his viewpoint somewhat adapted, as he was very adamant to have this convention adopted. But we note that it does not necessarily require the immediate destruction of a nation, but it does require a coordinated plan of different actions aiming at the destruction of essential foundations of the life of national groups with the aim of annihilating the groups themselves. So it lends that element of destruction in an existential sense. Now, does this mean from these more restrictive legal sources that it is irrelevant whether someone calls for the non-existence of a state or the destruction of a state? Well, no, is the short answer. So, for instance, in Krstic and in Karadzic, the Yugoslav Tribunal has noted that whilst such attacks, such as on cultural, religious property and symbols of the targeted group, may not constitute underlying acts of genocide, they may be considered evidence of intent to physically destroy the group. So they can be relevant, and in some cases were very relevant. Looking to the cases in which physical destruction was proven, we see, for example, here Ratko Mladic, who was the commander of the army of Republika Srpska, who was convicted for genocide for the events at Srebrenica in 1995. And if I go to the next slide, and you'll see his quote about taking revenge against the, quote, Bosnian Muslims, which were called the Turks as a derogatory term. If we go to the next slide, we see Directive 7 issued by Radovan Karadzic, which requires, by planned and well thought out combat operations, the VRS forces, in quote, to create an unbearable situation of total insecurity with no hope of further survival or life for the inhabitants of Srebrenica and Zepa. In that case, the question was really about whether the Bosnian Muslims in those enclaves constituted a significant enough part of the broader group of Bosnian Muslims in general. And it was ultimately considered that they were. But nonetheless, we can draw some lessons from those cases. For example, in the Karadzic case, the destruction of religious sites was considered, and it was considered potentially relevant evidence in relation to not just persecution, but also in relation to the genocide charges. And you can see here the link conceptually as to why that can be. This was evidence provided by Milan Tupajic, who was a Serb official, and so was quite well placed to understand the thinking of the perpetrator group. And here in court, you see questioned, he was asked, can you tell the court, give the court any insight into why these mosques were destroyed? His answer, there is a belief among the Serbs that if there are no mosques, there are no Muslims. And by destroying the mosques, the Muslims will lose a motive to return to the villages. By analogy, you can see that if a state is destroyed, removed, rendered non-existent, that of course, that will not just remove a motive to return, it will also remove a protective blanket, an entity which has the legal obligation to assure the security of its citizens, of the state human rights, and usually under its own constitution. And so my argument would be actually that calls for the destruction of statehood in some respects are a stronger source of evidence than calls, for instance, to destroy religious sites, which have been accepted as relevant evidence in determining genocidal intent. Another case which I'll mention briefly is that of Vojislav Šešelj, who you see here, who was a provocative leader of the Serb ultra-radical party, but he was not an official member of the Serb government. And that lack of formal power, in a sense, was quite critical in some ways to the outcome of this case and the way in which he was charged. So ultimately, despite having made many inflammatory comments, he was only convicted for the one speech that you see on the slide in front of you. There's an excerpt of the speech, which is taken from his own book, which he made in Hrtkovci, basically calling for the expulsion of Croats from that area outside to what is now Croatia. Despite that, he had made a number of calls denying, for instance, statehood, denying that the, quote, Islamic fundamentalists should be allowed to, quote, roam around Serbian lands and dream of setting up a pan-Islamic state which would spread in the Balkans. He also said of Macedonia that it was a state as artificial as the Muslim one and as artificial as the Montenegrin one. These are all invented nations which we will abolish, close quote. Now, he was not charged with genocide. And from that, you can draw certain lessons. I think partly it's because of, in a sense, his lack of formal status. Formal status in the authorities is not a requirement for genocide, but it seems that that may have played a part in not seeking that bigger charge. It also could be that his involvement didn't link directly to, for instance, the mass executions in Srebrenica. So, of course, that context is very important. But alongside that type of context, you could look at other actions by the accused, and you could look at, for instance, if they praise and reward perpetrators of specific crimes on the ground, so to speak, or grant immunity to them effectively or de jure by refusing to take proceedings against them. And so that context will really help you shape your understanding of their statements, so that even statements that may seem quite formalistic and abstract, such as denying statehood, could be, in combination with that type of evidence, taken to be genocidal intent. Of course, dehumanizing language and demonization is quite typical of incitement to genocide, and we see that here from the Rwandan tribunal cases of, in this case, Nahimana, where they have the infamous publication of the speech that a cockroach, as in the Tutsi, who were the victim group, cannot give birth to a butterfly. And these types of statements were used and repeatedly disseminated through radio, newspaper, and created an atmosphere in which, as we all know, the around 800,000 Tutsis were killed over a period of approximately 3 months, or maybe 4 months. So you can see that that type of language is particularly incendiary and can go in combination with the denial of statehood. We see here another excerpt from the 10 Commandments of the Hutu, in which it talks about this separation of the groups and traitorship for joining with or marrying someone from the Tutsi, the protected group. Now, in the remaining couple of minutes, if I bring this back to the Russia-Ukraine context, which I started with, there are some interesting lessons to be learned. Firstly, I would say that if a commentator, for instance, were contending that in the abstract, a certain entity, let's say Kosovo, for instance, did not meet the legal criteria for statehood under the Montevideo Convention of population, fixed territory, a government, and ability to conduct international relations. To me, that is one thing, and I think would not be the typical type of evidence that you'd be thinking about genocidal intent. On the other hand, if the person in question is making these denials of statehood in an incendiary context where the population being targeted is particularly vulnerable, and particularly if they are subject to physical violence at the same time, and obviously invasion would be a relevant factor there, then it puts a different shine on those statements. Also, the credibility of the statements is significant. Are they demonstrably falsifiable? And are they inconsistent, potentially, with other statements that are being made? So, for instance, in the Russian context, an individual looking at the situation and assessing it might look at, for instance, the fact that Russia has agreements in which it refers to Ukraine essentially as a nation state. There's a 1995 bilateral agreement between the Russian Federation and the government of Ukraine, in which the parties guarantee the free and equal rights, development of the Russian national minority in Ukraine and the Ukrainian national minority in the Russian Federation. That would seem on its face inconsistent with statements denying the existence of Ukraine, such as those we can see, for instance, by former Prime Minister Dmitry Medvedev, who's made a series of provocative statements, and you see one example here, where he says, Ukrainianness, which is fueled by anti-Russian poison, is consumed by the lie concerning its own identity. This is all one big fake. This phenomena has never existed in history, and it does not now. So that falsifiable type of statement would certainly be relevant when you're assessing genocidal intent. As mentioned, the context and the vulnerability of the state in question is important, particularly if there's a context of aggressive conduct by another state, particularly a neighboring state. I think also the contemporaneous taking of actions, such as detaining individuals of the targeted state, depriving them of necessities of life. You could imagine electricity, water supplies, etc. And then, of course, if there are executions, sexual violence, torture, these are all factors that have been regularly taken into account in inferring genocidal intent. And the other factors which I've mentioned go more to the nature of the speech, and where there is excessive language, where there is non-professional language, inflammatory language, and signal sending, such as we saw from Rwanda and we see in other inflammatory statements, that will certainly put the statements into the pool of forensically relevant evidence. So with those statements, I will come back to my final point, which is that whilst, in my view, my personal view, denying that a state exists per se is not definitive proof of genocidal intent. It can be relevant and, depending on its nature, highly relevant evidence of genocidal intent, but you would typically prove this in combination with other statements and, importantly, kinetic violent action on the ground within the power of the statement maker to control. So with those comments, thank you very much for your attention, and I'll pass back to the organizers. Thank you.
Matthew, for this very informative presentation, especially indicating the importance or the difference between the legal understanding of the genocide and this what is being used often by the politicians. So it makes a difference for politicians. Politicians can use much stronger words than lawyers, judges, prosecutors do. And I also want to underline that we often talk about the genocide as the most serious crime, as the most violent crime, the biggest atrocity crime. But on the other hand, it's never good to concentrate just on proving the genocide, because before the genocide happens, there are many other crimes being committed. And it can be like building through the ladder, building starting from war crimes, from other crimes against humanity, which may lead to the genocide in the end. Hopefully not, but this is what I wanted to say. Now I would give the floor to Dr. Deborah Ruiz Verduzco. She's the head of the fund, Victims Fund at the ICC, and she will be talking about the future of reparation, how the future of reparation may look like for Ukraine perspective from the ICC. Ms. Deborah, you are with us. The floor is yours.
Also an honor to follow the presentation of Dr. Gile. I want to thank the organizers, the University of Warsaw, as well as the Kharkiv Human Rights Protection Group, the EU-funded project Bravo Justice, as well as the International Association of Penal Law Polish section and the Sunflowers Foundation for inviting me to this event. As it was mentioned, I am the executive director of the Trust Fund for Victims at the International Criminal Court. I will be explaining what that institution and mechanism does, as well as speaking about the issue of reparations for victims of the most serious crimes under international criminal law, which include genocide, crimes against humanity, war crimes, and the crime of aggression. And it is an honor to do so on the 75th anniversary of the Convention of the Prevention and Punishment of Genocide, as well as a few days after the International Day on Human Rights and the International Day of Defenders, Human Rights Defenders, all three concurrently happening around December. Speaking of the convention is very important framework, because the 1948 convention, as the name of the convention indicates, seeks to prevent and also punish the genocide. And then with the convention, we see a very important historical mark in what we have right now as the international system. The evolution has entailed first looking at actions at the international level, so between nations or between states, in terms of the responsibilities that states owe to each other. And an important element is there in terms of the numerous conventions that establish obligations of states vis-a-vis other states, as well as vis-a-vis the international community as a whole, especially like through the Genocide Convention, which is considered to be an erga omnes obligation in terms of the prevention and the punishment. That means it's an obligation when a genocide is committed. It's not something that is committed against another state or against individuals, but against the international community as a whole. Another point in the evolution of international law has to do with the differentiation of individual responsibility. That is, differentiating the acts done by states and the acts done by individuals and the responsibility that those individuals have towards others. The landmark development in international law were the International Military Tribunal established in Nuremberg and then in Tokyo around the Second World War, after the Second World War, and then, as it was mentioned already, the tribunals established by the UN Security Council to prosecute the crimes committed in the former Yugoslavia, the ICTY, as well as in Rwanda. And these tribunals were established because the Security Council recognized that acts committed against individuals threatened the peace and security that the Security Council was obliged to preserve. And therefore, these tribunals were implemented as mechanisms of the United Nations Security Council. Then, in terms of the evolution, we have also a very important landmark, which is the Rome Statute that established the International Criminal Court, which helps the international community advance in many areas. The first one is establishing a charter that defines and consolidates the definition of those crimes as the most serious crimes under international criminal law. That is also marking principles as well concerning the non-application of state immunities or privilege or individual immunities. So even a head of state or a queen or a king are able to commit those crimes because the responsibility belongs to them regardless of the functions that they have. Another important principle is as well the non-prescription of these crimes, therefore allowing the prosecution in time to be maintained. And certainly the Rome Statute established an institution that is able to prosecute those crimes against individuals. That is the International Criminal Court. And this Rome Statute embeds in itself also the obligation that states have themselves to prosecute these crimes also by reaffirming the principle of complementarity. That means that it is in the first place the states who need to prosecute, and then the ICC can come in a complementary manner when states or for cases where the states are unable, are unwilling to act. Another important development with the Rome Statute of the International Criminal Court was the charter that defines the crimes. That is, it includes important proscription of the crimes, including the use, conscription, and recruitment of children for use in the conflict. As well as crimes of a sexual or gender-based nature. And finally, the biggest jump that has been made in terms of the evolution on international criminal law and international law through the Rome Statute has been creating and consolidating the right to reparations to victims. By recognizing that any individual that is convicted by the ICC, the judges may decide to order also a reparations award. And this has been crystallized in the practice of the court, meaning that the 5 convictions that have been issued by the ICC to date have received also a reparations order. The reparations order vary between $1 million to date $31 million, and depending on the number of victims and the number of charges that the individuals have been prosecuted for. The Trust Fund for Victims, that is part of this ecosystem of accountability through the Rome Statute, is a subsidiary body of the Assembly of States Parties that is governed by a board of directors that has the authority to manage the resources that are mobilized by a secretariat that is created in relationship to the ICC or embedded in the ICC. So myself, I lead the Secretariat of the Trust Fund, and all the staff that work there, we are ICC staff of the registry. And the registry of the courts provides the support for the Trust Fund to do its work in terms of design and implementation of programs of reparation. I will be then now speaking with this background on the developments in international law of the issue of reparations. And why is this important? Because as the Convention on Genocide states in its name, the focus of the international society or the international community has been on prevention and on punishment, which are very important components of the right to redress. The right to redress is composed and is embedded in international human rights law and has elements concerning access to justice. That means that victims of crimes are able to report that crime to the authorities, are able to receive guidance about how to navigate the judicial institutions, are able to receive information about the proceedings or the legislation that applies to their case. And also, the second principle concerning redress is the effective, impartial, prompt, and thorough investigations, which is achieved through mechanisms like the International Criminal Court or domestic jurisdictions or special mixed mechanisms of prosecution. But the third principle in international human rights law concerning the right to redress is the principle of reparations. And so now I will be moving to that component of reparations. The issue of reparations must be understood in three different ecosystems or regimes of international law. Between states, the articles on state responsibility that seem to crystallize customary international law that were prepared by the International Law Commission and endorsed by the General Assembly in 2001 provide that wrongful acts by states create an obligation to make a full reparation for the injury caused by that internationally wrongful act. That wrongful act could be the violation of a treaty or the violation of an agreement concerning borders. And the injury refers to any damage that may be material or moral caused by that wrongful act of the state. And the principles on self-responsibility indicate that the reasons or the causes or the intention of the acts of the state have no bearing on their responsibility, including to repair that injury caused to another state. This obligation can be owed to a state, to another state, to several states, or to the international community as a whole, for instance, for when genocide is committed. And the forms of reparation that are spoken of in the context of state responsibility refers to restitution, compensation, and satisfaction or recognition. Responsibilities between states are enforced through different mechanisms. The International Court of Justice may award reparations for damages to persons and property. Also, there are claims commissions that are ad hoc mechanisms that consider complex legal claims resulting from upheavals. Examples include the United Nations Claim Commission, the Iran-USA Claims Tribunal, the Eritrea-Ethiopia Claims Commission, that between them may resolve between a number of, a dozen of cases or up to 4,000 claims, for example, in the context of Iran and the United States, with awards that go up to $52 billion dollars marked as damages against a state. Also, the damages can be benefited not only by a state, but also by individuals. And each claim mechanism may allow for flexibility in determining who can access those claims. At the moment, in the context of Ukraine, as you may know, the Council of Europe, together with numerous states and the European Union, created a register for damages that is based in The Hague for any damage caused by the aggression of the Russian Federation against Ukraine. And it seeks to serve as a record to create documentation and of evidence and claims concerning damages, loss, or injury caused on or after the incidents of 24 February 2022 in the territory of Ukraine and extending to its territorial waters and to the natural and legal persons concerned. It is important to mention this mechanism because there will probably be an overlap between claims for damages, loss, or injury and the notion of reparations. But claims for damages are different to reparations, and I will be speaking in particularly about how they're different in a moment. Reparations derive also and are existent in the human rights framework. And that means that these are reparations that are owed by a state towards individuals whose rights have been violated. So that is the first difference between claims and reparations. Claims have to do with the loss or injury or damage to property, and there doesn't need to be a determination that a crime or a human rights violation has been committed. Simply, a house has been destroyed, and therefore I can claim damages for the loss of that house. It could be that that house was a legitimate target in the context of an armed conflict, because under international humanitarian law, that house was a legitimate target. But if it's determined that it is possible to raise claims for that target, especially considering the illegal nature of the war in itself, then you have access to the claims. When you are speaking about reparations, we're talking about the violation of rights, and especially to individuals. Numerous conventions and mechanisms of human rights anticipate and foresee the right to reparations. The European Court for Human Rights also is able, under the right of remedy, to order reparations against states for the benefit of individuals whose rights have been violated. And this reparation, the obligation concerning reparations, applies in the context of the conflict of Ukraine, not only against Russia, who may owe reparations in the context of human rights violations for their own individuals, their own nationals, as well as Ukrainian nationals, but also there is an obligation on the part of the state of Ukraine to provide reparations, even if the state of Ukraine is not the responsible of the violations. So under international human rights law, Ukraine has also an obligation to provide reparations. And there has been already announcements by the Ukrainian government to initiate processes to look at how those reparations can be delivered. And efforts are currently underway to consult victims to determine what could be the scope of those reparations and how can they be institutionalized. Another form of reparations has to do with reparations owed by individuals towards other individuals. And this takes place in the context of the International Criminal Court currently.
Dear Deborah, I will just ask you to slowly go to the end. I'm sorry, but we have some time limitations.
Very good. I had anticipated 3 more minutes and I will be closing. Thank you. Ukraine, while not a state party to the ICC, has accepted the jurisdiction of the court through declarations submitted in April 2014 and April 2015, meaning that the International Criminal Court has jurisdiction over acts committed since 21st November 2013, and that includes the annexation of Crimea, the war in Donbass, and the current conflict. If the cases raised by the prosecutor currently or any future cases end up in conviction, the court may order those reparations, and it will be for the Trust Fund for Victims to implement them. The reparations may be funded from the assets or property seized from the individuals that are convicted, or may be funded through voluntary contributions by state or private entities. What are these reparations and how can they look like in the context of the ICC, but also in the context of any initiative that the Ukrainian government may also initiate? So those mechanisms can be made through judicial orders or through administrative programs. And there are important principles to be followed. These principles derive from the jurisprudence of the International Criminal Court, and it includes ensuring that reparations do no harm to victims, ensuring that reparations are prompt, are proportional and adequate, respect the dignity, do not discriminate, and do not stigmatize victims, that are designed and implemented through a victim-centered approach, ensuring accessibility and consultation with victims, that the age and of the related harm and the best interests of children are considered, that they are gender inclusive and sensitive, and that recognize specific harm caused, for example, by sexual or gender-based violence. Reparations must respect the right of defense, and they require states parties or other stakeholders to fully cooperate. Reparations, examples of what has been implemented at the ICC or elsewhere that would be applicable to Ukraine as well, include addressing physical or health affectations, mental health affectations, the way that education, health, housing, or family life is affected by the crimes committed against victims. It can address economic harm caused to victims or communities. And it could include also reconstruction of cultural property in buildings or protected cultural property, as it's being done in the case of the Almaty case in the ICC. Sexual gender-based violence reparations include fistula repairs, HIV treatment, as well as addressing the situation and the condition of children born out of rape. In the future, considering environmental harm caused in Ukraine, individual victims and reparations may include thinking of how that environmental harm can be repaired. To conclude, we hope that the jurisprudence and the practice of the court can help in the future Ukraine decide what are the best forms of reparations, and that also it is considered whether, and we are in the process of doing so, the Trust Fund for Victims can issue programs of assistance in Ukraine if that is considered to be contributing to the rights of victims. These programs can be launched on the initiative of the Board of Directors, and the Trust Fund will be participating in consultations throughout the coming year to determine the feasibility of starting such programs, also in collaboration with the Ukrainian government, and of course, subject to the interest and the availability of funding. Important concerning reparations, that we differentiate them from reconstruction that will need to take place in Ukraine. Reparations must be accompanied by recognition of the harm done, and that recognition needs to be official. They must prioritize the most vulnerable victims and should focus not only in the result of how can these enormous damages and harms be repaired, but also in the process, in the way that reparations are designed in full consultation with victims, and that also consider memorialization and symbolic elements, which mark a very important difference to claims or development or aid, humanitarian aid initiatives. Thank you very much.
Thank you very much, Deborah, for your very informative presentation. This is always a challenge with keeping the time also for the moderator. And I will invite to the speech Dr. Anton Korynewicz. He is the ambassador at large at the Ministry of Ministry of Foreign Affairs of Ukraine. And a very short comment. I remember more than a year ago when the full-scale invasion against Ukraine started, Ukraine from the very first day was demanding the special tribunal for Russian aggression. And initially their requests, their claims were treated with kind of reservation, I would put it this way. But actually now I think that more and more states, also the European Union as such, is supporting the idea, however controversial. And I want Dr. Korynewicz to speak in more details about this question. I hope that Mr. Korynewicz is with us. I hope so. Yes. So
yeah.
There's okay.
Good afternoon
morning.
from Kiev. Good afternoon from Kiev, dear colleagues, Madam Moderator. I hope that the connection will be stable. Just 2 days ago, we faced a big Russia's hackers attack on one of the biggest Ukraine mobile and internet operator, Kyivstar. So I hope that the connection would be stable, but please forgive me if something goes wrong. We do feel some technical difficulties now in Kiev. It's of course a pleasure and honor to be able to talk to you today on behalf of the Ministry of Foreign Affairs of Ukraine. And it is always a pleasure to talk with our Polish colleagues and to cooperate on all the issues in relation to our accountability efforts. So I'm grateful to the organizers of the conference for being able to talk today. And as our previous brilliant presentators talked, it is really important to do this within the days when we commemorate and mark the 75th anniversary of the Genocide Convention, the 75th anniversary of the Universal Declaration of Human Rights. And we are also proud and feel a part of our heritage and legacy, in particular due to the legacy of Lviv University School of Law and Raphael Lemkin, Sarah Herschlauterbach, Louise Zon, who really made a great impact and great influence to the development of contemporary international law, in particular, which deals with human rights protection and accountability for the core international crimes. So I'm really grateful to Madam Moderator for stating from the very beginning that Ukraine pushes for the establishment of the special tribunal for the crime of aggression against Ukraine since the very outbreak of the full-scale invasion by Russia to Ukraine. And it is part of our legal response to this brutal, illegal war of aggression Russian Federation is waging against Ukraine. So there are several legal, I would say, tracks of response to that aggression. In particular, the named register of damage, work on the compensation mechanism, investigation by the International Criminal Court with relevant orders of arrest. But we also, and of course, our case in the International Court of Justice on the allegations of genocide, filed just 2 days after the full-scale invasion started on the 26th of February. But we do believe that in order for us all to be able to say that the full and comprehensive accountability takes place, we do believe that it is important to have accountability for the crime of aggression against Ukraine. So that is why we started this work more than 1.5 years ago. And really, for the first time, we felt some skepticism and some different reactions from international partners. Some of them said that Ukraine should use the existing international mechanisms and tools. and shall not invent anything new. But I think that within this year and a half, the perception of this question really changed from not if but how. So not whether we need to establish something, some mechanism for the crime of aggression against Ukraine, but how to do that. And I think, and I consider this change to be a very important one. And really, when we started in March and April 2022, with several resolutions of Parliamentary Assembly of the Council of Europe, then preceded by several resolutions of other parliamentary assemblies of international organizations, European Parliament. Today, we have the core group on the establishment of the special tribunal, which includes representatives of 40 states, plus several international organizations. We also have the work of the established International Center for the Prosecution of the Crime of Aggression against Ukraine, ICPA, or how some of our partners call it ICPA, working in The Hague on the basis of joint investigation team, in the premises of the Eurojust. And we believe that ICPA is already a value itself, because this is the first international effort to investigate the crime of aggression in case of its real perpetration after the World War II. But we also believe that apart from being a value itself, ICPA is the first step to the establishment of the special tribunal, because we do believe that the important investigative job done in the ICPA, in particular on national investigations of the crime of aggression against Ukraine, on defining the scope of persons who should be brought to accountability for the crime of aggression against Ukraine. All this work of the ICPA will be used in the special tribunal. So, of course, since the year and a half has passed since our work started on this idea, on this concept, we are happy with the interim intermediate results, which we have, in particular, the mentioned work of the core group, establishment and work of the ICPA, support to the establishment of the tribunal from parliaments, governments, international organizations, parliamentary assemblies of international organizations, and I'm happy with the level of support which we have from Poland, from our Polish friends and colleagues, both on the level of the government, namely the Ministry of Foreign Affairs, and on the level of Parliament, with the relevant resolution of the Parliament of Sejm. So I think we're on a good track. But of course, the main result we still need to achieve is the establishment of the special tribunal, which we try to achieve this result in particular through the work of the core group to find the solution, to find the landing zone for the establishment of the special tribunal. So why it is so important for Ukraine to establish a special tribunal? Well, first of all, we currently use all the possible international legal mechanisms and tools to bring Russia as a state to international legal responsibility and to bring Russian citizens to accountability for their core international crimes and other violations of international law and human rights law committed in the territory of Ukraine. We do value cooperation with International Criminal Court, and of course, International Criminal Court is a principal body of international criminal justice, and our prosecutor's office cooperate and coordinate with the Office of the Prosecutor of the ICC on a daily basis, and we do believe that the recognition of jurisdiction of the ICC and investigation of the ICC of the situation in Ukraine, starting from the end of November 2013, gives the ICC the appropriate possibility to act and to act effectively and actively. And of course, we were happy to see the first two arrest warrants for Vladimir Putin and Maria Lvova-Belova for the alleged war crimes of illegal transfer and deportation of Ukrainian children. But we also hope that these arrest warrants are only the first ones, and that we will have more arrest warrants from the ICC against the Russian citizens for not only war crimes, but crimes against humanity and the crime of genocide. But we do feel that this accountability gap, which there exists for the crime of aggression, and the lack of ability of the ICC to exercise jurisdiction in relation to the crime of aggression against Ukraine is crucial. Because, first of all, the aggression of the Russian Federation against Ukraine is the biggest aggression at least in Europe, after the Second World War. So there should be legal response to this act of aggression and relevant crimes of aggression. Moreover, this aggression is recognized as aggression in the resolutions of the United Nations General Assembly, also for the first time for many years. So again, this is another element and another argument why there should be accountability for the aggression itself. And also it is very important that in our context, without the crime of aggression, we wouldn't have had not a single war crime against humanity, or element of the crime of genocide committed by Russians on our soil. So in case of Russian-Ukrainian war, it is a crime of aggression which is the root cause of all the mass atrocity core international crimes committed on the territory of Ukraine. Whereas there may be other different situations in other continents, in other regions, where war crimes against humanity are committed without the crime of aggression itself. But in our particular case, our people and our land, our nation didn't know what is a single war crime before the Russian Federation committed aggression in 2014. So we believe that having accountability for this root cause is of principal importance. Moreover, we also understand that having the active and effective cooperation with the International Criminal Court, we cannot have accountability for the crime of aggression in our particular case in the ICC due to constraints on the exercise of jurisdiction of the ICC in relation to the crime of aggression laid down in particular in Article 15 bis and 15 ter of the Rome Statute. We, of course, are aware about the current situation and the idea from several governments to table the diplomatic proposal to amend the Rome Statute of the ICC in order for the ICC to have the same provisions on the exercise of jurisdiction of the crime of aggression as for the other three core international crimes within the jurisdiction of the ICC. But we do believe that this proposal will take a lot of time. This proposal, there are no understandings how this proposal may finally end up due to the fact that there may be different positions within these negotiations. But no matter how this proposal and this negotiations end, we assure that this proposal and these supposed amendments will not be able to cover the crime of aggression against Ukraine, which we currently face. So having big respect to the work of the ICC and cooperating with the ICC, we are of the idea that we need a separate special tribunal for the crime of aggression against Ukraine. And we do believe that many states and many partners who support us in our international efforts do feel the same. And that is why, in particular, they work together with us in the core group. Those of them who support the ICC to the best of their abilities, they understand that this aggression cannot be left without legal response. As for the nature of the tribunal, it is obvious that the most important question is the choosing of modality, of the modal option for the establishment of the tribunal. This is a core issue from all the other issues flow. And of course, the participants of this honorable conference know that there are two options which are being discussed widely, including by academics, scholars, and experts. The one option, the one model is to establish a special tribunal on the basis of a bilateral agreement between Ukraine and the United Nations with a relevant resolution of the United Nations General Assembly, which may authorize or request the Secretary General of the UN to enter into agreement with Ukraine on the establishment of the special tribunal. The second option being the option which is supported also by some of our international partners, is the establishment of the internationalized tribunal. International judges, international prosecutors.
I'm afraid that this what Ambassador
Recording in progress
just happened. Can you hear us, Ambassador?
I can hear you. We are also having the air raid siren just immediately now. So I think it is also due to the fact that the connection isn't stable. Sorry for that. Sorry for that. Yeah, it's our connection story. So the second option I will repeat. This is the establishment of internationalized or hybrid tribunal on the basis of national jurisdiction of Ukraine with relevant international elements, which some of our international partners support, but we do believe that such a tribunal, whenever established, should not be part of Ukraine's judicial system, because it should not be a kind of a bilateral response, a response of only the victim state towards the aggressor state. And moreover, there are some other issues, which in particular are about the impossibility of making amendments to the constitution of Ukraine during the martial law, which is now enacted. And moreover, we also believe that the tribunal should not be the purely domestic one and should not be able to render judgments only in the name of Ukraine. So two options are being on the table. I'm sure the discussions are widely known to international scholars and academics, but it is also obvious for us that we need to look for alternatives, for third options, possible third options, which might enable the establishment of the special tribunal. And this is in particular what we are trying to do now, to find the effective, legitimate third option, which might enable to establish a special tribunal. And we will see how we may proceed with this issue. So in general, to finalize, the establishment of the special tribunal, as Madam Moderator mentioned, from the very beginning of the full-scale invasion of Russia to Ukraine, was a priority for Ukraine's government on the track of individual criminal accountability. It is still a priority for Ukraine, and it is an inherent part of the point 7 of the peace formula by President Volodymyr Zelensky, and point 7 is called restoration of justice. Now, we believe that without accountability for the crime of aggression against Ukraine, we will not have the full comprehensive accountability for all the violations of international law against Ukraine in place. So we do believe that accountability for the crime of aggression against Ukraine must be ensured, and the perpetrators of the crime of aggression against Ukraine must not go unpunished. We hope that we would find a solution, a landing zone, which will enable us to establish an effective and legitimate special tribunal for this cause. We, of course, do have the idea and the understanding that this tribunal will be in nature an ad hoc one, so it will cover only the crime of aggression against Ukraine and only in our particular situation, in our particular circumstances. So we do not want and we do not have the desire to create something bigger, because, of course, we understand that for all the other cases and in normal situation, ICC should cover this issue. Maybe the last point on my side would be that having this brutal Russian aggression against Ukraine, the biggest aggression in Europe, at least after Second World War, we are sure that for contemporary international law, it is a must, it is obligatory to have accountability for this crime of aggression, because it is very important for the rule of law, for international legal order, for the principle of non-use of force or non-threat of force, and for the very concept of the crime of aggression itself. Because I do believe that if in this particular case, in this particular instance of the Russian aggression against Ukraine, there will be no accountability for aggression itself, for the crime of aggression itself, the crime of aggression might remain in international law only as a historical concept. And professors participating in this conference will be only able to give paper tasks for their students to study and research what aggression was in international law. I do believe that we all don't want this to happen. I believe that we all want the international rule of law prevail, the principle of non-use of force or non-threat of force to remain the foundational principle of contemporary international law, and for the concept of the aggression and the crime of aggression to not be a historical one, but a real one, and it is, I'm sure, important for all of us international lawyers who work in this sphere. I thank you for your attention.
Tak, co буде moja ukraińska mowa, but now I will be speaking English. So we are closing this session. I think it was very interesting. I'm not sure if we managed to put any questions to our participants. We need to go for a coffee and start in a moment the next session. And I made a mistake because I did not introduce myself. My name is Anna Adamska-Galant. I'm a lawyer from Poland, former judge, also international in Kosovo. And for last 5 years, I work in Ukraine as the key international expert on the judicial reform. So thank you very much.
Four speakers, Dr. Karolina Wiercińska of the Institute of Legal Studies of the Polish Academy of Studies, International Public Law Faculty, Dr. Hanna Kuczyńska, the Institute of Legal Studies of the Polish Academy of Sciences, the Penal Law Faculty, Mr. Andrzej Kostyła, and Barbara Błońska, Dr. Błońska and Dr. Kazimierz from the University of Warsaw Core Crimes Center. And let's start with Dr. Karolina Wiercińska, who will talk about Lemkin's idea leading to the Genocide Convention. Good afternoon. Hello, everyone. As Dr. Adamska-Galant introduced this session, I am indeed going to discuss the root causes and the origins of the Genocide Conventions. And that is, I'm going to make a reference to Lemkin. In his writings, he had not foreseen the Genocide Convention. Back in 1945, in his article about modern crimes, Lemkin pointed out to this crime that needs to be investigated, and countries should be busy doing that and prevent genocide. And Lemkin was thinking about three groups: national, religious, or racial groups. So he believed protection should be granted to these three groups. However, he mentioned that genocide as such has a trans-border nature, and it has to be internationally investigated, whatever that meant at that time. In 1946, so closer to the beginnings of the process to design the conventions, he wrote that this was a crime consisting in the destruction of, national religious groups, etc. But he also said that it should be prosecuted in the country where it was perpetrated. No international tribunal was on the horizon at that time yet. He believed national systems would suffice. He also believed that suspects of the crime of genocide should not be treated as political criminals to avoid extradition. But he also said that in countries where genocide is perpetrated, these countries should be accountable before the Security Council of the UN. So he believed there should be a dichotomy in accountability, and it should apply to both the individual who perpetrates and the country which violates international law. Later, Lemkin authored the first draft of the genocide resolution, and Panama and Cuba leaders were encouraged to promote it. And so what you are looking at are the key ideas by Lemkin that says that Lemkin took satisfaction in the fact that the resolution talks about genocide as an international crime, but at the same time, the resolution also indicates that indispensable national legislation has to be adopted. So he believed it would the convention would require national legislation in order to be forcible. And in the resolution, what we find, and Lemkin again was quite proud of it, we find an idea of writing a genocide convention. What he hadn't actually expected international community to be swift in moving in that direction. Then we look at the draft, which was submitted by the Secretariat, and that draft was actually a draft of the Genocide Convention. Why am I referring back to this? Why? Because Lemkin had been working on this draft as an international expert with two eminent lawyers of the time, Vespasian Pella, a Romanian, and Aurélie de Vabre, a French lawyer. The draft the draft was presented to them, and they only spoke about differences of opinion between them, which I'm going to refer to. So protected group techniques and the jurisdiction, national and UN jurisdiction, if appropriate. The first article of the draft was on the protected groups, and there's a disconnect here. Out of 3, we have as many as 5 now. The next slide will allude to this in more detail. However, let me draw your attention on this slide to the fact that there is cultural genocide. That's a new concept, and Lemkin had been very forceful in promoting this idea. He had known this type of genocide from his own experience. He had documented Germany's cultural genocide. So he believed cultural genocide should receive a strong treatment, such as transfer of children, ban on publishing books, or ban on the use of national languages. Now, the draft covered 3 genocide techniques: biological and ethnic annihilation of biological, psychological, and cultural annihilation of the groups. But 2 other experts were in opposition. Donnedieu de Vabre and Pella didn't believe that should be protected under the convention. They believed it was excessive, and the protection would not be relevant. They believed that cultural genocide should be part and parcel of minorities convention. Now, Lemkin saw the burning of books, saw the destruction of libraries, the bans on language, and penalties for using a language. He had strongly believed that cultural genocide was a must in the convention because he understood what it could potentially lead to, what kind of havoc reap. The original text of the convention is as follows. You can see that the protected group are 4. There's an ethnic group, but there's no language group. There's no language group just because the 2 other expert had opposed this. They believed that language group would be too much associated with cultural, and cultural should be the minorities protection resolution. We have biological and psychological destruction as genocide techniques. Cultural aspect is only retained in the form of forceful displacement and transfer of children. And Lemkin was, in fact, quite proud that at least that strand was maintained. Then we look at Article 10 of the draft convention, which talked about the establishment of an international tribunal, international court, which hadn't been Lemkin's idea, because he had believed that it should be done at national courts. But convention does give treatment to international courts. The two other experts had been in favor of an international court, and actually it was the French idea to put an international court in the convention. And 1948, where the resolution was adopted, Lemkin thought it was the host's privilege to add something to the draft, and so he believed it was a legitimately included French idea, but he thought only the big fish should be penalized in front or by an international court. Small fry should definitely stay in the jurisdiction of the national courts. Now, Grenadier de Fab thought it should be a chamber, that the international court should be a chamber of the International Criminal Court, but it couldn't be reconciled because judges at ICC have different competences than the sort of competences that would be relevant here. In the international law conferences, lawyers discussed the international law enforcement, and two rapporteurs had been hired, Alfaro and Johnston, who believed it could be a separate chambers of the of ICC, but the idea was thought as premature. Now, Lemkin believed, again, national criminal judiciary was well developed, and this was supported by Poland. By the way, Lemkin had nothing to do with Poland. He was an independent expert. Now, should an international criminal court be created as part of a genocide convention? Now, all experts said in unison that it should be decided by the General Assembly of all countries, so that should be left to the sovereign of all countries. Today's provisions of the conventions are, as you can see, and as you know, what we have provisions on the obligations of state signatories. But we have provisions on the establishment of international criminal court, with the primacy being retained in national systems. So if national systems cannot be successful prosecuting a crime, trying a crime of this type, it would be escalated to up to the international court. So basically, this is the format in which ICC operates today.
discussions on the projects focused on competencies of this court, and Lemkin believed that it's a good idea to communicate information to Secretary General, who would later inform other bodies of the United Nations that an act of genocide has been committed. In modern regulations, in Article 8, we have a reference to the UN Charter. So Lemkin's and Palace proposal has been embraced. And to conclude, to recap, what was the impact of Lemkin's concept on today's convention? Well, it needs to be stressed that he believed in individual accountability and the accountability of a state which failed to prevent genocide from happening, what has been reflected by provisions of the convention. There is a striking difference when we compare Lemkin's notion of persecuting crimes. He wanted national courts to take the lead, and he was reluctant to see establishment of an international criminal court. The convention provides for 14 protected groups versus several groups listed by Lemkin. But if we read carefully Lemkin's justification, he believed that all stable and durable groups should benefit from protection. So today's convention should be interpreted broadly in terms of protected group, and this is what the Rwanda tribunal did. Genocide could never be treated as a political crime, and this has been reiterated in the convention. So we cannot say that it's Lemkin's convention, but it contains a number of ideas advocated by Lemkin. Thank you very much for your attention.
Bardzo dziękuję za to.
Well, thank you very much for introducing us to Lemkin's concept, and over to Hanna Kuczyńska, who is going to discuss how Lemkin's concept became a reality and what are practical implications of his ideas today. Well, thank you very much. This panel is dedicated entirely to one man and his ideas that he has managed to put into real life. And I always wonder, how could it be possible that one man had such huge impact on defining, on creating a type of crime which is very much discussed today, and this panel of our conference is dedicated to him. Genocide, as defined by Lemkin as the main crime against the international order, is now adopted in real life into international and national law. There is not a single international tribunal or international court which has no jurisdiction over genocide. The Rome Treaty of the ICC Matthew Gillette discussed interpretation of crimes from this category. The International Criminal Court has respective jurisdiction for genocide, and elements of genocide defined by the Rome Statute correspond to the 1948 Convention, Article 3. So we have the same acts aimed to annihilate an entire religious or ethnic group as such. I have clicked on the English version, but as you can see, there is a mistake in the Polish translation because it should be national, ethnic, racial, or religious group as such and not such as. It is a fundamental mistake which was indicated when the Rome Statute was translated into Polish. So Article 6 of the Rome Statute provides the definition and more detailed definition may be found in paragraphs where elements of crime are defined in greater detail. It is a binding document which specifies elements of genocide. Elements of the definition are explained, and we can see which acts constitute genocide. So genocide must demonstrate a pattern. The perpetrator must demonstrate the intention of destruction, and this intention doesn't have to be fulfilled in whole. It's sufficient if it is in line to a certain pattern. So the intention of destruction must be confirmed in a specific case. The person against whom the attack is directed must belong to the same group, and the perpetrator must intend to destroy a national, ethnic, racial, or religious group as such. And damage must be done to one or more persons. So problems that occurred are reflected by negotiations and discussions held by Lemkin with other international law experts. The first issue relates to the scope of penalization and the scope of protected groups. Which groups are subject to protection? Professor Wierczyńska has discussed it in detail. I just wanted to say that we can still mention different approach, which have one thing in common. All international criminal courts examining genocide are trying to adopt a wide range of protected groups. For example, the UN Darfur Committee and the International Criminal Court for Rwanda we're relying on the efficiency of legal standards. So the significance, the relevance of the group should be defined in such manner to ensure effective protection. Later, we started analyzing how protection is defined and from whose perspective, the victims or the perpetrator. The perpetrator may act because he or she might know that the victim belongs to a specific group. So such proposal for the definition was recommended by ICTY, but was rejected. Right now, by the International Court of Justice has adopted a mixed approach. Another problem was related to the number of victims from a single group. So there is an ongoing discussion, can murder of a single person be classified as genocide? This is what Lemkin believed right at the start. He claimed that genocide is protection enjoyed by individuals, not an entire group, because it is men who enjoy protection, not an abstract society. So this problem has not been resolved until today. We agree that the attack should be launched on a significant or significant part of the group. And this concept is presented by the ICC, which has ruled in a genocide case that this significant group must be relevant, and relevance can be identified in terms of quality or quantity to identify whether an act targeted at an individual was aimed at the entire group. So quality-driven approach must be combined with a quantity-driven approach. So knowledge-based approach is also relevant, or even a double intent crime, because if we read the definition of the crime, not only the perpetrator needs to have an intent. For example, I, on purpose, create certain conditions for a specific group, and I need to make a contribution to annihilation or destruction of a specific group. So let me click back. There are two concepts here, because genocide must be planned. We need to have a plan, and we need to have a behavioral patterns. But then within such assumptions, only leaders could be charged with genocide. And what about soldiers, ordinary soldiers? Do they have the intent of destroying a specific group, or are they merely executing plans? So there are two concepts, two approaches. So we may prove dolus specialis approach. For example, if a soldier has specific motivation, the soldier may be also only executing a plan and have no intention of destroying a specific group, as he or she is only following soldiers and thus cannot be charged with genocide because there is no intent. So charges can only imply crimes against humanity. The second approach enables us to prove knowledge-based approach. So it's awareness of the perpetrator that he or she is participating in genocidal activities. So right now we tend to adopt the second approach, and we also criticize it as using evidential backdoors, as we're interfering or inferring the existence of the perpetrator's consciousness from fact patterns that surround him. So the fourth problem is related to proving that actions of the perpetrator constituted a realistic threat for the existence of a given group. Lemkin tied genocide to a specific plan that must be conducted in line with a specified model. So if we adopt the approach of a realistic threat, this would be a result-based element, and the crime could be persecuted only after the group was exterminated in whole or in part. That's why the ICC, in its rulings, has adopted that there must be a realistic threat, but the act doesn't have to be committed entirely. It's sufficient if a threat was realistic to a specific group and not hypothetical. So the ICC is forcing us to evaluate whether the plan was effective and potentially successful. The fifth issue we have mentioned is securing the presence of the accused. So this was brought to attention to the attention of the ICC. It's the case against the former president of Sudan, Omar al-Bashir, who was charged with genocide. The second version of the arrest warrant was issued in July 2010, and the former president has managed to evade the court. President al-Bashir was traveling across African Union countries, and he was not detained, despite the fact that many African parties have ratified the Rome Statutes. Some countries have declined, some have no reacted, and some countries like South Africa convened a court and decided that yes, that there should be extradition, but by that time al-Bashir had left the country. So this case is not over, but it's nearing to a positive end because al-Bashir is not a president anymore. He was sentenced for corruption in Sudan, and he's now charged with the crime of coup d'etat, and he's charging capital punishment, and we do not know whether he will be provided to the ICC by the current authorities of Sudan. So yes, we will be able to secure the presence of the accused, because without the accused present, the case cannot continue. In terms of national jurisdiction of countries in genocide cases, immunities may be an obstacle, but this is a topic for another conference.
Zbrodni ludobójstwa okazały się trudności dowodowe. To znaczy trzeba bardzo dużo dowodów, żeby udowodnić nie tylko istnienie ludobójczego zamiaru, ale również
acting with intent and committed specific crimes. We need to prove evidence for a wide spectrum of activities, existence of a plan related to a protected group, intentions related to extermination of that group. So that means that the bar has been set very high, but right now we have very interesting capabilities. We can use digital evidence, the so-called digital fingerprints. For example, Facebook. Facebook can be used to summon a perpetrator for a hearing. There are special reports compiled by NGOs, open source information. For example, very often perpetrators are being photographed during executions or with decapitated bodies. And because we have so much evidence which is investigated by AI, proving the scale and the plan has become much easier. And the last problem I would like to discuss today, in the doctrine, the discussion whether or not the genocide is the crime of all crimes continues, and there are two concepts. Decisions of international tribunals claims that this is the gravest international crime, And among the grievous crimes, this tribunal has the duty of to punish. The crime of genocide is singled out for special condemnation and opprobrium. And tribunals have adopted a special stigma attached to this crime, and there is a special evidence threshold. That's why there were so few proceedings related to this type of crime, which is very difficult to prove. And it's such a grave crime, it's very difficult to attribute it to a perpetrator. And the sequence of crimes in all statutes, including the Rome Statute, indicates that this is the genocide which is penalized first. We can also evaluate harm of a given crime. So, for example, a war crime may lead to a bigger number of victims than genocide. But in such case, we are assessing the gravity of a given crime and not a crime in abstracto, the quintessence of it. That's why I suggest to recognize it as the gravest crime in respect of functions of international criminal law, which has very important protective and preventive function, individual and general, what has been mentioned by Lemkin. And he wrote that penalizing the crime of genocide will deter and discourage Germany from committing this crime. So we are thus protecting a whole group. What we deem to be more important than protecting individual lives. Of course, when we analyze it in abstracto. So international criminal law, by recognizing it as the crime of crimes, it's protecting special values, which the international community considers to be very important. And I look forward to discussion with Professor Wierczyńska. My time is almost up. I have 1.5 minutes. From the very beginning, the investigation concerning crimes in Ukraine focused on genocide. As indicated by the Ukrainian declaration of the 15th of February 2015 and the PTC decision. And there is no doubt that individual acts, murders, extermination, tortures, creating living conditions for Ukrainian civilians could provide a basis for creating living conditions for Ukrainian civilians could be sufficient to accuse perpetrators of genocide. But we may wonder, and this is the time to do that, whether this evidence is sufficient to prove genocidal intent of leaders and individual troops, whether or not evidence we have collated, statements, declarations, propaganda, is clear enough to prove the intent of leaders and executors of this genocidal plan. Are they sufficient? And so far, different pros and cons have been presented based on the same evidence. Because there is no information gap, we are all using the same evidence. And many experts, English-speaking experts, have stated that the practice of international courts tells us to be cautious because much more is needed to sustain a case. There is no dolus specialis, and each statement, like President Biden's statement, who claimed that genocide has been committed, his statement has been called reckless, an overstatement, too generic. And on the other hand, there are concepts which call to take into account the historical and political context of genocidal acts committed by Russians. We are dealing with the same narration all the time, ever since from the times immemorial, ever since the Rurik dynasty through Holodomor. Russians keep on denying the existence of the Ukrainian nation. They are challenging the existence of Ukraine because this has been perpetuated by the Russian propaganda. So these were not random acts of violence or aggression. This violence comes as an after effect of the narration that dominates Russia. So the criminal intent and genocidal intent should be interpreted in the context of propaganda and historical developments. Those plans intend to destroy Ukrainian statehood. Matthew Gillett mentioned that the notion of Ukrainian nation has been challenged. This plan is meant not to remove the Ukrainian government, but to destroy Ukraine's cultural distinctiveness. So again, we have a very clear cleavage between two concepts which may be divided into East and West European attitudes. So the interpretation of genocide in Western Europe, in English-speaking countries, is marked by the Holocaust, because extermination in the West means biological, physical extermination. It's an act which leads to physical destruction of a protected group. Where it seems to me that in Eastern Europe, which has experienced partitions, occupation, lack of statehood, Russification and Germanization, we are more sensitive to cultural extermination, destruction of culture, and the nation, depriving the nation of its national identity. So to recap, this discussion started by Lemkin continues. Is cultural, social, economic genocide, psychological, political genocide, can it be recognized as genocide in the context of a specific crime? And now it's the time when this discussion becomes relevant again. If we were to change paradigms set by the international tribunals, we are at this point in time. In practice, we see a clash of those two attitudes which stand in conflict. And if an international tribunal or a national court will be examining a case of genocide, we will need to decide whether cultural genocide, which is taking place in Ukraine, can it be recognized as genocide in the context of international criminal law? And thank you very much for your attention. I think it works. Okay, so thank you once again for your presentation, and I think this is an introduction to another presentation. Dr. Błońska and Dr. Kosyło will be delivering it about the obligatory transfer of children in Ukraine, and one of definitions of genocide implies forced transfer of children from one ethnic group to another one. So
the Polish
you are
delegation was
going
opposed
to
this
touch on that.
concept, and there was a clash of two lawyers, Manfred Lux versus Lemkin. Alfred Lux, another eminent lawyer representing Poland at the ICC. Lux believed that this amendment is inappropriate and it blurs the image of what has happened to the Greek children. Poland has always, and it never changed in our political history. We were perceiving ourselves as a party saving Greek children, while the civil war continued. So it was very much politicized. We see it as a merit. So the beginning was very different. And this amendment was very often portrayed by Greeks that Greek children were kidnapped during the civil war. Okay, so let me now focus on the situation of Ukrainian children very briefly. There are many conflicting data on this phenomenon. Some mention 700,000 children who have been displaced. Ukrainians mention 150 up to 200 or 300,000 displaced children. There are no accurate data. There is a special center for displaced persons, and it mentions only 20,000 displaced children. Why do we have stark differences? I have little time to explain methodology. Very often, the Russian Federation, well, before it was charged by the ICC, but it also counted children and families. So that's why they have fantastic figures of several 100,000, but these are accompanied minors, not unaccompanied ones. Okay, so when are children transferred? Unattended children. There are three major categories. So forced and mass transfer from children's home. So children are taken from centers, so both hospitals, both orphanages, and something that is very specific for Ukraine. I mean, their parents have are still have custody rights, and 80% of children at Ukrainian orphanages are children who have been put in those care centers by parents who enjoy the ultimate custody to them. And the same goes for dormitories for very gifted children or disabled children. So I know that the Russian Federation has treated them as unattended minors, and whole centers, whole schools were relocated to the Russian side. And this has been confirmed by different reports. For example, the head of Kherson administration boasted that he took 40 children from the local orphanage to Crimea. We know that 80 children from an orphanage in Olesko were taken to Crimea, and we know for sure that 3 schools from Kherson were taken for rehabilitation to Crimea. So it looks like the Crimea is a very popular children's destination, but they have returned. Something that seems to be the worst case ever, forced transfer at filtration camps. For example, when people are detained at filtration camps where their loyalty and willingness to cooperate with the occupier is tested. Unfortunately, very often parents who end up with children at such filtration camps, if parents are seen as a politically subversive element, their children are taken away and sent to a Russian orphanage. And we know for sure, because also one of the reports quotes the case of Yevgeny Mashadov, who has been negatively filtrated at a camp, and 3 of his children were sent for adoption to Russia. Luckily, he was released 4 months later, and he managed to have his family reunified. And one more case, a legal guardian of a group of children from Mariupol who was staying at the hospital. He was also negatively verified, and children were sent to Russia. And children who were sent to summer camps who did not return after summer to their families. Well, very often some children with their parents' permission from occupied regions were to go to Crimea to take a break from the war, to pull themselves together. And some of those regions were later liberated by Ukraine, and children had many problems to return to such liberated regions. Russian authorities demanded parents to come and fetch them. So at the beginning, it seemed that it was mission impossible. Madam Lvova Bielova was explaining, well, they cannot leave. They cannot, those children, those poor children, no one is picking them up. So Russia is taking care of them. But indictment has speeded up this process, and children started going back home. And today, we do not really know if children from all camps were reunited with their families. So to recap, why did the ICC decide to prosecute the illegal transfer of children? Well, Ukraine wanted the ICC to deal and persecute this crime because the fate of children was very important for the Ukrainian authorities. It's also a crime that is very difficult to evaluate in the context of proportionality. Everything is obvious when children are taken away. We're not talking about military goals. And it's very difficult for Russia to indicate that by snatching children, they are protecting themselves from NATO's attack. So it's a crime that is difficult to defend and easy to prosecute. Well, thank you very much for giving me the floor. In my part of the presentation, I would like to focus on 2 elements. The first one, I want to confirm the intent of genocide in forced transfer of children in Ukraine. And secondly, the second problem I would like to focus on is proving the ethnic group. Well, first of all, the Convention on Prevention and Punishment of Genocide and the Rome Statute, which is repeating the content of the convention. They mention a number of forms of genocide. So it may be murder, it may be grave bodily harm, it may be willful development of living conditions which leads to reduction of childbirth or annihilation of a specific group. But if we were to classify activities of Russians in Ukraine, the convention also mentions the intent to exterminate a part of the group, not the entire group. So if an attack is launched on a part of the group, it is also a crime of aggression. And talking about protected groups, in case of crimes committed by Russians in Ukraine, Ukrainians should not be perceived as an ethnic group, but a national group. So a community of Ukrainian nationals who are creating a state. Such interpretation is right, is correct for international criminal courts, especially prosecutor versus Akayesu. At Rwanda ICC or prosecution versus cheats in the ruling of the ICTY. So tribunals present an interpretation which provides that protected groups also include citizens, nationals, regardless of their ethnicity. So protection extends also to Russian-speaking citizens of Ukraine who form the community, the Ukrainian community, as well as people with other ethnic background, with Jewish, Polish, Hungarian roots. So the first key elements when we qualify crimes committed by Russia, we need to focus on the national group of Ukrainians. So all Ukrainian nationals, regardless of their ethnicity. So I think this criterion is exhausted. The second element, the intent may refer to a part of the group which may be annihilated. For example, if we want to exterminate Ukrainian elites, which is reflected by Putin's publications on the historic unity of Russians and Ukrainians, or publications of Timofeytsev, who wrote what should be done with Ukraine. Such publications clearly show that the intent was to exterminate Ukrainian elites, which are described as Nazi. There is even a mention of re-education camps or death camps for the Ukrainian elites. So the intent to exterminate a part of a national group, Ukrainian elites, is also the intent of committing genocide. To prove the intent, we need to take into consideration activities pursued by Russia, by Russian politicians that reflect a systemic approach aimed at destroying an ethnic group in whole Arab or in part. So, in the light of the former aspect of genocide, transferring children from one group to another one, such intent may be reflected by legal amendments made by Russians, and especially the fact that while the occupation of the Donetsk, Lugansk, and Crimea continued and was completed after the beginning of the full-scale invention. What I mean is facilitation of adoptions of Ukrainian children. Personal details of such children are redacted or destroyed. So when those children grow up, they will not able to see that they were born in Ukraine to Ukrainian parents. They will be raised as Russian children. So we are talking about a classic example that may be classified as genocide according to provisions of the convention, so a transfer of children from one group to another one. Activities that prevent children that were taken to Russia to retain their identity. Books, textbooks in occupied regions, books in Ukrainians are destroyed. They are burned on a mass scale. Education is available exclusively in Russian. And this is the after effect of a policy pursued by the Russian elites. Everything started with Putin's article on the historic unity of Russian and Ukrainian nations, which basically denied that Ukraine exists. The article defined an objective for the state apparatus to destroy the Ukrainian identity. So when we talk that historically Lemkin favored the concept of cultural genocide, and yes, we are now witnessing cultural genocide. So extermination of a part of the Ukrainian elite and forcibly transferring children to Russia. I think those two practices have been proved, and I think that rulings will be issued in the future.
Thank you very much for those exciting presentations so far, Putin and Ms. Belova, the Russian children's ombudsman. They have been charged with the illegal transfer of Ukrainian children to Russia. But of course, everything is a matter of evidence. Everything is a matter of evaluation to be conducted by courts. And let's hope that those people will be charged eventually. It should be stressed that last year it seemed impossible that someone like Putin may be charged with anything, that he may be indicted. I remember when it was happening, I was in The Hague, and it was a funny situation because
I was talking to TVN News about who may be indicted for war crimes committed in Ukraine. And when we were talking, when I was live on TVN network, she said, "Oh, latest news, breaking news. Putin has been charged," and I had to watch out and be very careful not to use any harsh words. But I was amazed that it came to that, and something that Dr. Kuczynska said, the war in Ukraine is the most documented conflict in history, which is unfolding in front of our very eyes. Everyone has a smartphone, and we all feel and realize there is a stream of evidence provided to the Ukrainian prosecution service. Our speakers have highlighted that genocide should be treated by stock of the thought, and I recommend East-West Street by Philip Sand about the genesis of crimes against humanity, genocide, about Rafał Lemkin and Herbst. I'll talk to great lawyers from Lviv who were both engaged and committed, Lemkin as an independent expert and Park as an expert working for the British government. So it's a great read. So right now it's time to begin our discussion. If you have questions or comments, lunch is getting cold, but hopefully we are going to make it in time. Thank you. Hello. I would like to congratulate you on excellent papers, Professor Kuczynska and Karolina. I would like to ask several questions. One of Professor Kuczynska, the issue of evidence, absolutely essential. We heard comments from the moderator about that. Quite broad evidence available online. If we really take a close look at this, it might be misleading. This documentation is delivered indirectly. It's said to be manipulated. Both parties are apparently busy staging and fabricating and doctoring material. Accusations come from both sides. However, the genocidal policy implemented by Russia, this concept is, I believe, unquestionable. It cannot be contested. It appears to be true. If you look at the developments in Russia, if you could follow the Russian TV, which is now Portugal, you could see waves of hate speech against Ukrainians, contesting the existence of the Ukrainian state. Well, that's not going far enough. It's questioning the existence of the Ukrainian nation. However, the propagandists felt they were probably moving too far, and they backed off just a little. I'm not sure about now, but it's probably similar. So we have ample evidence on the genocidal policy. Its policy of extermination is characteristic of the existence of the Russian state ever since Ivan. Let me ask Professor Kuczynska, how do you envisage using evidence of a state policy towards genocide? Practically, how do you envisage actually using that evidence in court? Thank you.
Już, tak? Bardzo dziękuję panu profesorowi Radzikowi. Jeśli chodzi o kwestię dowodową, to
bardzo dziękuję panu profesorowi Radzikowi.
Thank you very much, Professor Radzik.
ale dostępnego
As far as evidence is concerned,
oceniania i potwierdzania wiarygodności dowodów.
it's not simple. The matter
I rzeczywiście mieliśmy do czynienia ze scenkami nagrywanymi
complicated but still accessible
służby rosyjskie
toolbox
i
of
wrzucanymi
gathering
na TikToka,
and
mającymi wykazać, czy na YouTube'a, mającymi wykazać,
and validating evidence. We do have scenes shot by Russian forces and then posted on TikTok. These were meant to illustrate that it is the Ukrainian military that is behind atrocities and war crimes, designed to show that a rocket falling on a shopping mall was a Ukrainian one, but there was no shopping mall, but a munitions factory. And we have evidence suggesting that these films had been doctored. There are specialized hacker groups that specialized in this, and we have evidence suggesting that these are not genuine. This is not genuine footage. And only NGO activist footage appears to be legitimate, but it can again be digitally proven. You look at the shade analysis, you look at chronolocation, you look at satellite readings, you look at CCTV footage. Sometimes you could see a rocket falling on a shopping center in a CCTV footage. The size of it, the direction it flew, etc. And evidence put together by hackers and NGOs was used in a case tried in Amsterdam on M817 shooting and the destruction of Ukraine. And this evidence, even though it was unlawfully collected, was actually admitted.
Jako dowody na zaistnienie ludobójczego planu i ludobójczego zamiaru.
There is a whole analytical effort to look at Russian propaganda with a view to proving genocidal intent and genocidal plan. And there's a resolution adopted by Verkhovna Rada, the Ukrainian parliament, making a statement that, based on evidence, genocide has been perpetrated. And there is a whole array of statements in evidence suggesting that Russian statements are in fact designed to destroy Ukraine, but it is mainly in the area of destroying the cultural identity of Ukrainians. Ukrainianness is to be destroyed, not Ukrainians. Thank you.
Ja bym się chciała odnieść do tej zaczepki, którą pani
Professor Wierczyńska wants to take the floor.
w swojej prezentacji.
Please.
Ale najpierw między słowami muszę powiedzieć, że my razem pracujemy, więc my się dosyć często ze sobą spieramy.
Professor Kuczynska made a little provocative statement in her presentation, but in between the lines, to say that we work together, so we debate things quite often. We're an old marriage, old couple, you know, arguing about
Wydaje mi się, że już to rozstrzygnęłam tutaj.
about milk in the fridge, kind of.
merytoryczne. Przede wszystkim
So
wydaje
we
mi się, że
debate
powinniśmy
these
mówić o
two
hierarchii zbrodni, to myślę, że byśmy mówić o
two
agresji,
sides.
zbrodni. Trybunał Norymberski
I
wyraźnie
was
wskazywał,
looking
że
forward to
to
more
agresja jest tą
argumentation.
najpoważniejszą
Now,
zbrodnią.
I
Jakby
believe
tak
that if
rozsądnie
there's a
spojrzeć, proszę
hierarchy
państwa,
of
to najpierw
crime,
musi się
it should
pojawić
be
agresja, żeby potem
it
pojawiły się
should
inne zbrodnie, czy
be
to zbrodnie
going
przeciwko
back to
ludzkości, czy
Nuremberg
zbrodnie
tribunals, and
ludobójstwa.
aggression
Poza tym statut
is the
wiedeński
top crime
Międzynarodowego
first.
Trybunału Karnego,
Must
jak już
come
się odnieść
aggression in
konkretnie
order
do
for other
jakiegoś
crimes to be committed
mówi,
against
że
humanity,
statut
against
obejmuje,
or genocide.
Trybunał
Apart from
obejmuje swoją
that,
jurysdykcją najpoważniejsze zbrodnie wagi międzynarodowej.
the
I
Roman
wymienia
statute of
tam
ICC
literowo,
says that the
niecyfrowo,
statute
literowo wymienia ludobójstwo, zbrodnie
that the
przeciwko ludzkości, zbrodnie
ICC
wojenne i agresję na przykład
covers
po miejscu.
all
Teoretycznie, ale
crimes
przecież
in
nie
its
dlatego, że ona jest
jurisdiction,
najmniej
and it
poważna, tylko
lists
dlatego, że w tamtym czasie
genocide, crimes
twórcy
against
statutu
humanity,
wymienili definicję
war crimes, and
dla
aggression
agresji,
as
nie
the
chcieli na
fourth,
pierwszym
as the
miejscu
fourth
wymieniać
on
agresji,
the
której
list.
nie mieli definicji, bo by to po
It's
prostu
fourth
trochę
on the list, not
niefortunnie,
because
wydaje mi
it's
się,
the
wyglądało.
less as the least
Ja się
serious,
spytałam
but because originally
moim zdaniem
there was
dla mnie
no
przynajmniej jest
definition of
autorytetem, jak
aggression.
chodzi o
They don't want to
definiowanie
list it
zbrodni,
at
kwalifikowanie zbrodni
the start
ludobójstwa.
without a
Dlaczego
proper
wszyscy się
definition. That
spotykają,
would
żeby od
look a
razu
bit lonely.
nazwać zbrodnię ludobójstwem? I zapewne
I
państwa,
asked Mira
jak się
Chabats
rozpoczęła
about
pełnoskalowa
defining
agresja w
crimes
lutym
of
zeszłego roku w
genocide.
Ukrainie,
Why does
zauważyliście, że
everyone
wszystkie media
insist
nalegały na to, żeby
on
jak najszybciej doprowadzić do kwalifikacji
on
tych zbrodni
calling
popełnionych
this a
przez
crime
Islam
of genocide
jako
when the
ludobójstwo?
full-scale
I do mnie
invasion started
kilkanaście razy dzwonili dziennikarze,
last
czasem
year?
ci sami, którzy mówili, czy już
Everybody
to jest
was
ludobójstwo, czy pani
after
mi już powiedziała, że to jest ludobójstwo? Ja
qualifying
zawsze
this as
powtarzałam, że
genocide.
najpierw musimy wskazać na zamiar, a
And
wskazanie
I
zamiaru
received
jest bardzo
dozens
trudne
of
dowodowo i
calls from
będziemy troszeczkę
journalists.
musieli,
Now,
powtarzam
is
to,
it genocide
szanowni
already? Could you
będziemy
now
troszkę
tell us
musieli
that
działać, jakbyśmy układali puzzle, to
it's
znaczy element
genocide?
po
I
elemencie
always
składać
responded,
taką
we have to
układankę.
prove intent, and it's kind of difficult to prove. It's hard to find evidence. And it's like putting puzzle pieces together. It's a big puzzle to put together. So when I asked Mira Chabats why everyone was after this, because he said because of genocide is a gold medal and everyone wants one. And I suppose that explains a lot why there's so much pressure. Genocide is a very hard crime to prove, as is crime against humanity. Indeed, when there are attacks against civilian populations, well, they originally were designed against an armored vehicle or soldiers passing by. Civilian casualties are collateral damage. Thank you very much. This is my response.
Jak rozumiem, ja już nie mogę.
Challenge me. Okay, there's more provocation. Would anyone like to follow up and follow through? I can't, I suppose.
Że jedna zbrodnia musi być mniej ważna od drugiej. Agresja nie jest
Ania,
najmniej
over to you
ważna. Jest
if you want to
zbrodnią
respond.
założycielską, zbrodnią
Very
matką.
briefly.
Wielu innych
Well, it's not
zbrodni,
that
ale ani
that one crime has to supersede or be more important than others. Aggression is the founding crime, it's the mother crime.
nadrzędne, tak jak w prokuraturze
It's
jest
not Holodomor. All Holocaust started with an aggression, mind you.
i różne znaczenie.
They are not secondary.
Opieram się przy słowie hierarchia.
They are not
Rzeczywiście William Szabas
sort of low in hierarchy, but they have different meanings.
mamy do czynienia z ludobójstwem.
Hierarchy, okay, I'm not insistent on using the word hierarchy, but Shabazz did mention that he believed there was no genocide happening in Ukraine.
No minimum penalty, maximum up to
So,
30 years in case of
The
exceptional
Rome
gravity,
statute
life
applies the
imprisonment.
same penalty for crimes.
That doesn't say
No
1, 2,
minimum
3,
penalty,
3, 4,
maximum
1, 4,
up to
3,
30
2.
years in case of
It is what it
exceptional
is. It
gravity,
depends on
life
the situation.
imprisonment.
So in Congo,
And that doesn't say
widespread
1,
and
2, 3,
systematic
3,
attacks
4,
directed
1,
at
4,
women
3.
for the purpose of raping
Is
them
what it is.
is
It
the most
depends
serious
on the
crime.
situation. So,
1 every 4 women
Congo,
of Congo, 50 million
widespread and
population,
systematic
25 women,
attacks
1 out
directed
of
at
4
women
have
for
been
the purpose
raped.
of raping them is the most serious crime. One every 4 women of Congo, 50 million people, 25 women, 1 out of 4 have been raped. No worse than crime against humanity in Congo. Ukraine, crime of aggression, mother of all crimes. Maybe the Holocaust, if it's written in the final solution and predates the war of aggression, certainly consider. So it depends. In every situation, you may find one crime that has, in terms of gravity and scale, will bring about the life imprisonment. So that's at least in terms of penalty. That one can argue penalty is not so important, but that's the argument.
Needs nuances. It's not black and white. And this
Yeah.
is what we also
Thank you
observe
very
in
much
court
for
of
this
Ukraine.
comment.
And judges,
Yeah,
prosecutors
definitely
are
international
aware
humanitarian
that
law
it's not like
needs
this, that if you
nuance.
have like a
It's not
case
black and
where you
white.
have,
This is what we also observe in the
Russian
context of
soldier
Ukraine.
charged
Judges,
with
prosecutors
killing
are learning.
Ukrainian civilian, it
It's
always
not like
means
this
a
that
war
if you
crime.
have like a
But
case
it
where you
needs kind of learning, training,
Russian
and,
soldier
understanding.
charged
This
with
was also
killing
underlined
Ukrainian
before.
civilian, it always means war.
Nie wiem, czy jeszcze
It
jakieś
needs kind of
komentarze,
learning, training,
uwagi. Coraz bardziej pachnie
understanding.
obiadem, powiem
This
w
was
ten
also
sposób.
underlined before.
Ja bardzo wszystkim
Nie wiem, czy jeszcze jakieś komentarze, uwagi, coraz bardziej pachnie obiadem. Powiem w ten sposób.
Small comments. I suppose the lunch is becoming more and more, scenty in the air. So I suppose it lures us. So thank you very much. Thank you for the presentations and the tensions and the clash and the debate in the panel. Now let's have lunch. It doesn't seem to be lunch; it's kind of dinner, early dinner. But whatever it is, let's take 45 minutes break.
Because I look confused, and I work at the chair of criminal studies, and I work with all organizers of this event. And I wanted to be here, sit down and listen and do nothing. But as it transpires that Maria Erhard, who was to moderate this session, she was appointed the Deputy Minister for Justice, and unfortunately, she was not able to attend this conference. But as a moderator of second choice, that's me. So this panel is dedicated to challenges in social policy. So we are now departing from very serious legal matters to focus on, I didn't want to say less serious, but definitely much more needed things which are more relatable to people. And Professor Katarzyna Celińska will present first of John Jay College of Criminal Justice, the City University of New York. She will deliver the presentation together with Dr. Katarzyna Witkowska-Rozpara of Warsaw University, but Dr. Witkowska is ill, but she's not seriously ill. Hopefully, she's going to join us on Zoom. So if everything goes well, Katarzyna will be sharing and co-hosting the presentation. Okay, so let's start with you. Good afternoon. Thank you very much for your invitation. Thank you very much for introducing us. As you can see, this is a shared presentation based on research findings. We have conducted research together. It's a joint project of John Jay College of Criminal Justice and the Criminal Studies Center at Warsaw University. So we'll be talking about terms, conditions, and operating methods of NGOs which were providing assistance to refugees from Ukraine. I will be discussing the profile of volunteers and problems affecting them in their day-to-day work. I will also discuss types of offered assistance, and Dr. Katarzyna Witkowska-Rozpara will provide more details. I hope that in her part of the presentation, she will discuss roadblocks and problems encountered by NGOs, and her recommendations will be presented in recap of our presentation. So those recommendations are suggested by people we have interviewed. So about the project, we have conducted partially structured interviews, and all topics I have listed will be discussed during in our presentation. So we have conducted 21 interviews with volunteers from 14 NGOs based in Warsaw. The study was conducted from 16th of October and was continued until the 23rd of November. So today we'll be presenting initial findings of the project. Let me start with the mission of the organization. And again, to quote volunteers and employees of NGOs, well, the picture they've painted indicates that there are two key missions. The first group, these are missions focused on specific type of aid provided to refugees from Ukraine, so humanitarian relief, providing them with dignified housing conditions, helping them to adapt in a new environment. And there are also other missions which mainly address the needs of all citizens staying in Poland, providing them with equal rights. We have gathered information from interviews. Like I've said, these are very initial findings, but they help me identify very different types of organizations that are helping refugees. We believe there is no specific profile of NGOs. They may share or have similar missions, but they are strikingly different. The way they operate are very different. I think every organization I've talked to was different, and that was very exciting. So I've decided to split NGOs into different groups. For example, number two, organizational development. Many NGOs started as grassroots initiatives. For example, people have come together during protests, and they've discovered they are like-minded. And they have realized that in order to be effective or to operate seamlessly as a group, as an organization, they need to start an NGO. And most NGOs I talked to had very similar history. Some NGOs have stayed in that format and some have developed further. I've called them traditional organizations. They became very professional. They have regular employees and they are applying for grants. Number three type of assistance, I think Katarzyna Witkowska-Rozpara is going to discuss it. Let me just mention the final item, which is very interesting. Hosting society education. Preparations are very important. the society of the hosting country needs to be educated. You need to tell people, to make people aware what to do when refugees arrive to their home country. Okay, different types of organizations we have mentioned in our report. For example, number 6, most organizations I've talked to had the sense they were not supported by the authorities. What was visible when individual volunteers had different litigations against them. So the minority had the sense the government is not supporting them, or some of them had the sense that the authorities are sabotaging their operations. Supporting NGOs. NGOs are supported with material support, with funding, with in-kind contribution, and the emotional contribution is also very important. It's a very complex issue, so in my presentation, I'm not able to cover everything. But all in all, I can share that at the beginning of the war, one of the respondents said Poland was like one big NGO. The civil society was active, ordinary citizens were active, and the government chimed in, but too late. So the wide public is also evolving. The public sentiment is evolving. A lot depends on the media, on visibility of different topics in the media. So let me focus on media now. NGOs believed that support demonstrated by the media was very limited. There was news coverage of the war. There were different releases on the national media, but there was very poor visibility on NGOs. The media did not publicize what NGOs and volunteers are doing as part of relief. I think one of the interviewers mentioned that we remained invisible. That discouraged NGOs, that they had no media support, and that public sentiment was changing. Funding and in-kind contribution, major grants came from outside Poland because the Polish government provided NGOs with little support. People who are operating within NGOs want the typical profile. If there is a profile, these are mainly women of all age groups, very different people from very different walks of life, many drivers, but also foreign nationals. For example, veterans from the US and Canada, or one of volunteers, people who are retired. What are the dominant features of volunteers? And again, I'm going to quote our interviews, our respondents. I think the key feature everyone was stressing was empathy. It takes a lot of empathy to work for an NGO. So we need to demonstrate the ability to put ourselves in the shoes of someone else. We need to be able to feel for other people. Someone else said that 50% of work is the ability to listen, the ease of interacting with other people, being open, the ability to distance yourself from all your feelings and emotions. So you really need to sacrifice and dedicate your time and energy. And you are not able to focus on your feelings and emotions, and you shouldn't be doing it. What are the essential skills? Well, skills were all important. For example, how to handle formalities, having contact, mainly to get formalities done, proved to be most important. Also, language skills. What are the risks awaiting people working for different NGOs? Like I said before, stress, frustration, but also questions: what's the point of assistance we are providing? Will refugees emigrate? Will they return to Ukraine? Are they staying in Poland? Would anything change for them if they knew what will happen next? Burnout. Those works is actually burning out all volunteers who are experiencing, who are empathizing with other people. One of our respondents mentioned that many NGOs were established when the war started, but their operations were not regulated. And of course, distribution of assistance doesn't go to people who need it most. And our volunteers, driven by the right motives, refugees are haunted by psychological issues, and our respondents have admitted that they have observed that refugees have been traumatized by war and occupation. Many of them admit we are not able to feel joy. They have a sense that it's not the right thing to do, because back home their fellow citizens who have stayed behind are facing such hardship that there are people fighting in the trenches, so it's not right to feel happy. They're struggling with adaptation. They are struggling with cultural differences, with language barriers and negative reactions of members of the white public who do not react very well whenever they hear Ukrainian or Russian. Some respondents have also mentioned systemic discrimination, what is particularly visible at official agencies and institutions. Another interesting aspect, the aging of refugees. Most refugees were young women with children or the elderly. And our respondents that senior refugees have very different problems, that we need to support them differently, and that it remains an issue because they are not trained, they have not been trained, and they don't know how to assist such people. They have not been trained in profound psychological issues, or they don't know how to help senior people. Crime. We've heard that very often refugees are victims of financial crimes or perpetrators. They are also potential victims of human trafficking. They also may be perpetrators, and volunteers have no idea how to address it, how to address domestic violence.
because they have not been trained in it. So over to Katarzyna Witkowska-Rozpara.
Aczkolwiek my jesteśmy w połowie prezentacji, ponieważ właśnie mam nadzieję, że uda mi się połączyć panią doktor. Aczkolwiek my jesteśmy w połowie prezentacji, ponieważ
We're halfway through with the presentation, and hopefully we can connect to Katarzyna Witkowska-Rozpara, who will take over. Well, I hope too.
Tak, słyszymy.
Hello.
Tak, bardzo dziękujemy.
Hello, can you hear me? All right, we can hear you.
Ale przepraszam, coś tam się
I'll try to show the second part of the presentation.
pana tłumacza słyszymy bardzo głośno i wyraźnie.
Nie słychać, ale...
My słyszymy ciebie.
I'm not sure if you can hear the interpreter out in the room. No, it's fine, actually. We can hear you. All right, then. Let's start and let's keep our fingers crossed. And I suppose the interpreting is going on and it's fine and it's where it should be. Apologies for not being here with you, but you don't want me to be with you because we are in an international group. We have this international disease that has moved in to my house, and I don't want to spread it any further. I will focus on the second part of the presentation, and I will show the types of aid and the biggest challenges that we have identified, and I will end with recommendations that have been suggested by NGOs. At the start of the crisis, we mainly focused on humanitarian aid, and on the slide you can see the key sort of quote that shows how short-term and how putting out fires kind of approach that was. Now, what happened later, after more and more months, and after the situation has settled in, if you like, the aid has changed. NGOs provided assistance to help people find location, find accommodation, and schools for children. So aid was provided in the context of trying to create an everyday life in Poland as normal as it can be achieved, so that this upended life can be mitigated, if you like. And of course, we were first and foremost interested to learn about the key challenges faced by NGOs, and we have lots and lots of conclusions. The time is constrained, so I would just focus on 4 things. Let's start with what we heard across the picture: lack of funding. We've heard, or lack of stability of funding. The migration or refugee crisis has shown the gaps in the funding system, and the fact that NGOs had to put all their hands on deck meant that shortages were inevitable. And mind you, the war has become commonplace. It has. We have all grown accustomed to it. Apologies for this phrase, but and that meant that some of the funding was no longer available. Has not always been available. Some of it was discontinued.
Przypuszczam, że coś się zadziało, że państwo...
I assume something happened and you couldn't hear me, but it's okay now. It's back to normal. I thought it was an emergency, but came live again. So the funding model that existed led to the dehumanization of refugees who became numbers rather than people. Another major problem was the lack of psychological care, mental care. Working in NGOs that are actively providing humanitarian aid is highly stressful, and there's a lot of burnout, and there's a lot of trauma. Therefore, activists needed to digest all that, and they were not receiving any support. So mental support and mental counseling has become one of the leading themes, actually. Now, this all hands on deck approach meant that many people were involved without any experience or expertise working with refugees. No one had trained them, no one had orienteered them in this kind of work. And these volunteers often reported having had anxieties coming to contact and having to meet the needs of refugees. Then, no legislation. The quote that you see shows the framework in which NGOs operated. There were many people who decided to act now, but there was no supporting legislation and regulation. So some of the activities were not really fully legitimate, to be honest, and we were not sure whether we met all the standards, whether we stayed in compliance. All we thought about was whether we can be effective in helping out. So the biggest recommendation based on all that is to ensure stability of funding. And a permanent source of funding was proposed, but also people suggested that we shouldn't use the statistics-based model to work on numbers of people helped, but to use a different system. The lack of stable funding revealed yet another shortage, and that is NGOs are trying to move away from a participatory model to a leadership-based model, whereby they would like to be represented by leaders who would be able to manage funding and represent them, to relieve organizations, charities from having to do so many things at the same time. We were told that the time was ripe after the initial worst moments. It's time that people have started working on skills, competencies, so that people can follow their talent, specialize, and improve their skills. That meant providing stability of employment and psychological counseling for NGO staff. And cultural assistance. There's another presentation devoted to this. No social integration can occur without an established national identity being in place. Only this can work smoothly if we ensure lack of tension between cultures, and if we create conditions for the Ukrainian culture to be nurtured and practiced on an everyday basis, even though the context is that of a Polish culture around children and adults who seek assistance.
Współpracy pomiędzy pierwszym a trzecim sektorem. To jest bardzo duże wyzwanie, tak? Natomiast nasi rozmówcy, nasze
Pracy pomiędzy pierwszym a trzecim sektorem. To jest bardzo duże wyzwanie. It's a big challenge, right? And interlocutors have told us that it's not, there's no expectation that government should pay for all things. The expectation is rather for government to be supportive rather than inhibitive. And please tell me if you can see it. Yes, it's marvelous. Thank you very much. Again, Maria Baran, Dr. Maria Baran of SWPS University. She will talk about culturally sensitive recommendations for entities supporting Ukrainians in Poland, and we're going to talk about results of a qualitative study. So I would urge you to exercise self-discipline in terms of time. 20 minutes, please. Before we start, I can see some echo. Oh, no, not anymore. Thank you very much for inviting me. And apologies, I am ill as well, so I cannot be in person. However, I am delighted, absolutely delighted that I can be with you, that I could listen to the previous presentation, because I will echo some of the points made earlier. And I would like to emphasize a different perspective, however. Our perspective in the study is very much psychologically, if you like, rooted. And the study, the results of which I would like to share with you, looks at Ukrainians before coming to Poland and after coming to Poland. I will show some slides and I will skip over some of the less relevant one. For us, the context is an unprecedented migration context, and the mental health of refugees, the mental resilience of Ukrainian women. Why? Let me explain. We decided to focus on the group that demographically was prevailing in the refugee stream. It's a highly feminine group, and female refugees are highest in numbers. And I want to show you the results of the study. However, as far as theoretical background is concerned, we wanted to look at psychological resilience, which is two-pronged. One related to the skills to counter mental stress and the coping strategies and competencies. So the study had the ambitious goal of focusing on both in order to develop recommendations for the third sector in terms of how to design and deliver aid to refugees from Ukraine. And to reflect the voice of respondents, we interviewed respondents using community-based participatory action research approach, which meant that it was scientific, but it was very much based on the community voice. And we evaluated activities or measures in order to see whether they have been effective and how and where they can be perhaps improved going forward. So there is the practical aspect of the study. We identified a sample of 33 Ukrainian women aged 21 to 65 who left Ukraine, landed in Poland and received humanitarian aid. The study was conducted last year between end of 2022, and we finished in February 2023. That was a qualitative study where interviews took a little more than an hour. And what I would like to emphasize is that because of the sensitivity of this social group, we took care to ensure the ethical aspects of the process. We didn't directly go into the traumatizing topics, and we had a psychologist, a crisis intervention professional who is supporting us. And only in the sample there were only 4 women over the age of 50. Here is the selection of topics that we asked questions about. We asked about emotions, but also coping strategies, challenges faced in Poland to adapt to the Polish system and society, a sense of stability, the potential conflicts and the well-being of children at school. We used a reflective thematic analysis to analyze the results, and here they are. This is the structure of analysis about the risk factors, and we have one overarching topic, the unachievability of normalcy. I don't have time to go through all those topics. Let me just show it that it's there, and let me just highlight one aspect that I would like to home in on.
You can see a map of factors which are supporting mental resilience, and one of them is stability. And because I have very little time, I'll start with problems, which were identified on a generic level, and I'm going to suggest their interpretation. Our main goal was to dive deep into mental resilience, but of course this topic was interrelated. I mean, we've collected many information about the things that played into it. So to be able to explain something in barely 15 minutes time, I've divided findings into 3 categories. So reasons behind inadequate and ineffective assistance. Very often we assume that we know better. We, those who are helping the refugees, we know what they need, we know what should be done, and what does it entail. A huge risk because needs of beneficiaries are not consulted. We are not evaluating needs. We are not assessing needs. And the things that we are doing are simply wrong. Something else that we are doing, and this needs to be actively eradicated, the stereotype of the refugee as a helpless, traumatized victim. So we like stereotypes because it makes things easier, but refugees are very diversified. There are people who have been struggling, that's true, but with support, with a helping hand, they are finding their bearings. They still have other needs which have not been fulfilled, but they are able to find a job, later an apartment, things are going to be fine. So focus on short-term activities. So that's obvious. That's number 3. And number 4, lack of cultural competencies. What is related to overlooking cultural differences? Very often we decide that the Polish and Ukrainian culture are so similar that refugees from Ukraine will find it very easy to accommodate in Poland, what isn't true. And I'm going to show 2 topics. This is about risk factor, psychological counseling for very difficult cases only. Very often Ukrainians are not prepared to embrace psychological counseling. That's the specificity of Ukraine. Psychiatry witnessed major cases of abuse. Very often political dissidents were closed and very often tortured in mental health hospitals, and this is something the older generation remembers very vividly. The Ukrainian public has very little knowledge about what psychologists do, how can they help them. So we've decided that most of them perceive psychologists as people who are helping people with very profound mental problems. For example, one of our respondents said, we had a great psychologist who was visiting us twice a week. Sorry, I need to close the window. And she would say, come to us if you need to talk. But we never went to see her. We never went to talk to her because we didn't need it. No one would visit psychologists back home because we didn't need it. And another quote, when we came to Poland, we were staying with some people for several days. Later, we had to go shopping. And we've decided that we're not going to see a psychologist because we don't really need it, that there are people who need it more. That's why we never had psychological counseling. And right now, another topic, not using psychological counseling. So survival first, basic needs reported by our respondents did not include psychological counseling. Very few people benefited from it. There were exceptions, but these are usually people who benefited from psychological counseling back home, but it wasn't a widespread need. For example, versus very fundamental needs such as food, shelter, etc. Someone said, and that's a quote, we are staying at a hostel. We feel safe here. But if someone is renting a flat, if they don't have money, if they don't have a job, they may feel restless. They may feel anxious. And last final quote, sometimes children get sick, they go to the same school, so we are helping each other. When we are at work, someone else can look after our children, and that's really valuable. And this is an example that would help me highlight 4 different categories we have seen. If we assume that refugees are people who are helpless and traumatized, this may lead to misallocation of funds. For example, one of foundations operating in Warsaw has allocated most of funding to psychological counseling, but they realized very quickly that those services won't be very sought after, so they've decided to reallocate funding. Examples of cultural differences, because we have very little knowledge about Ukrainian culture, we are unable to adapt help accordingly. So this is one out of many examples in cultural differences between our countries. I know I have very little time left, so this is the final slide I wanted to show you. Some recommendations are as follows. Those recommendations were our overarching goal. I'm selecting topics, but I want to leave you with something. So I have lots of other data I could not show to you today, but these are key recommendations. Consultations with beneficiaries, inclusiveness on many different levels. We need to discuss with beneficiaries about what they really want and need, and a short anecdote which shows how widespread this problem is. The media had contacted me 2 months ago. There was a problem in a kindergarten. A child from Ukraine was refusing to eat, and they suspected it may be the after effect of a trauma it sustained. And I've asked the journalist, have we talked to its mother? No, they said. So it's a paradox. We Poles who are helping Ukrainians, we are seeking for external experts, why the easiest way out is to consult local experts or parents or Ukrainians to fix and solve the problem really fast. Because, for example, if we talk to the mother, we would find out that it's not a trauma, but cultural differences. The child was not used to eating sandwiches we eat in Poland, but was used to porridge, which is not served in Polish kindergartens. So change in the menu would be simple, fast, and effective. Inclusiveness. We need to have diverse Polish-Ukrainian teams. For example, many solutions would never be designed if we didn't work in those bicultural groups. We need cross-cultural experts who have in-depth knowledge of Ukrainian culture. Another recommendation is to change stereotypes of refugees, because this creates many threats and may undermine efficiency of aid. Main existential needs. Our research was conducted 9 months into the Russian invasion. Most of the needs have not been satisfied. Of course, we are still in the weeds as a country. Poland did not take the final accountability for refugees, but we also need to be flexible. We need to embrace changes. We do have plans for relief provided to refugees, but we need to be able to flexibly reallocate funding because situation is changing as we go. And education and cultural competencies. This is something that has been mentioned in the previous presentation. Very often donors do not want to cover hobbies, relief, pleasures, pursuing interests, because they believe this is irrelevant. And our research has clearly demonstrated that it's one of the vital needs, because it creates stability, it supports mental welfare and well-being, and other findings confirm that there is no willingness on the part of Ukrainians to benefit from psychological counseling. So what can we offer alternatively? For example, we can offer courses and workshops for Ukrainian females, language courses or crocheting courses. And what Ukrainian women appreciated most about those courses were coffee breaks or tea breaks, which created an occasion for them to talk to each other. So this has very powerful prevention effect. It builds networks, it builds contacts, and helps Ukrainian women stay stronger. We also need cross-cultural assistance at school. We need to educate people about cultural differences because this will simply facilitate adaptation. After Christmas, we are going to publish our report. So if there is an aspect I haven't discussed today and you are interested in it, so please read the report, and thank you very much for your attention. I hope I didn't take more of your time than I should.
Bardzo dziękuję, bardzo mi przykro, że nie mogła być pani z nami osobiście, ale
Well, thank
cieszę się, że
you.
chociaż w takiej formie się udało.
Thank you very much. You were right on time. I'm sorry you couldn't attend this conference in person, but at least you could join us remotely. I think everything fits other presentations very neatly because previous presentations have mentioned cultural differences and cultural competencies. You have referred to cross-cultural conferences, and we are now going to talk about intercultural assistance at schools. This presentation will be delivered by Professor Mikołaj Pawlak, Agnieszka Kozak-Koszczak, intercultural assistance at schools, challenges related to organization of the education sector for children from Ukraine. You have 20 minutes. Okay, so perhaps I'm going to take the remote control from our host.
Kwestie techniczne rozwiązane. Mam nadzieję, że będzie tego typu utrudnień mniej niż przy połączeniach online.
Okay, so we have solved our technical problems, and let's hope that we will be free of technical glitches. Together with Agnieszka Kazoszczak, we are going to talk about intercultural assistance at Polish schools. This concept is embedded in the research project we are implementing, just two of us, in association with Marta Kindler. It's funded by the National Center for Science, and our presentation will cover all three missions of the university. So I'm going to discuss findings from our research. We are going to talk about what we present to students, and we are going to discuss how we interact with different stakeholders to change educational and social policy in Poland. So our action plan is to give you first context. Later, I'm going to give the floor to Agnieszka, who will present the legal framework, the role of intercultural assistance at Polish school. And later, I'm going to discuss postgraduate studies you can enroll to if you want to become, in the future, a cross-cultural assistant. So hopefully I'm going to blend all those three topics. So first of all, foreign national children are a frequent sight at Polish school. The prior to the war in Ukraine, the number of foreign nationals in Polish school was growing quite rapidly. In 2022, there were 70,000, or more than 1% of total Polish students in Polish school accounted for foreign nationals. And this number has remained high for a decade. This is when first research was conducted into such foreign students. This trend was a niche trend. In the past, the Polish Ministry of Education declared at the time that there were 19 cross-cultural assistants employed at different Polish schools. We know that the actual figure was 70. So this shows, this is a very interesting example. We are describing the reality. We are trying to make recommendations to the Ministry of Education, which is responsible for Polish school, which is promoting certain solutions. And as you can see, is taking absolutely no interest whatsoever in what is happening at Polish school. They don't even know how many cross-cultural assistants they hire. They haven't even tried to evaluate whether the institution of the assistant is effective or not. But following the beginning of the war in Ukraine, we had a surge in foreign children at Polish school, what meant that we also hired a bigger number of people to help them out. Right now, data from the official system of the Ministry of Education shows that several dozen people work as cross-cultural assistants. We know that the number actually stands at several hundred, so the Polish state doesn't know how many people are employed as assistants again. They are conducting and offering Polish lessons, for example, assistance, individual assistance to students. So 1,200 people have been employed thanks to NGOs, thanks to funding of multilateral organizations such as UNICEF. And there are also assistants who have been hired by schools, directly by schools, because funding has been allocated by local governments. So how does it look like? Agnieszka Kozakoszczyk is going to tell you more about it. Thank you very much. We've said that we are not going to discuss legal matters, but we need to focus on a single legal act, because cross-cultural assistants who, in line with the act, are teachers' assistants, and their work is regulated by one Polish act on the education law. The previous version of the act featured the same provision that persons who are not Polish nationals, who are subject to mandatory schooling and who do not speak the Polish language or its command is insufficient to attend Polish school, have the right to an assistant speaking their mother tongue who is hired by the school principal. Such assistant may support children for 12 months. Of course, it's very difficult in real life because 12 months you have students coming and going. So, it's not really followed in real life, and funding for hiring the assistant should be allocated by the municipality or the local government. The only required competence, which is specified by the Act, is that the cross-cultural assistant should have a command of the native tongue of the child. Very often this is the language the child also speaks, not necessarily the mother tongue of the child. Like Mikołaj said, despite the fact that this act has been in force for more than a decade, many cross-cultural assistants were hired by NGOs. Just to give you a figure for last year, I think at Polish schools, the bigger employer hiring cross-cultural assistance was the Polish Center for International Relief that hired 800 assistants. I think right now in Warsaw, UNICEF has hired 400 cross-cultural assistants. We know that 400 of them work in Warsaw alone, so you can compare it with the official data of the ministry, who has no idea what is happening at Polish schools. Cross-cultural assistants, that's how we call people who assist schools and their students. The act refers them as assistant teachers, and you can see yourself what's the difference on the semantic level. There are also emotional undertones. For example, teacher's aid, that's one-to-one translation in Polish, and cross-cultural assistant, that implies that this person is facilitating, that it's helping the school community. And teacher's aid is a person usually who is hired with funding obtained from the local government, and cross-cultural assistants are people hired on the same position but paid by different organizations. What do they do? And what is not specified by regulations? For example, regulations fail to specify required education of cross-cultural assistants. They fail to specify experience, competencies, the scope of responsibilities, the number of children such assistants should support. So there are also downers. Regulations fail to specify the number of children per single cross-cultural assistant, or the number of assistants per one child. For example, in some schools you have one student from Brazil and one cross-cultural student, and another school with 120 Ukrainian children and 2 cross-cultural assistants. So who should an assistant support? Is the assistant for the child, or is the assistant assisting a teacher? In real life, this person is helping the children, teachers, parents, and other teachers. And something else that may stir doubt, assistants should be hired by the school principal, but regulations fail to specify how and by whom assistants should be employed. And it's very often the case, unfortunately, and this is what we've seen in the past decade, that local governments did not provide funding, arguing we have no reserve in our budget. There were some schools that were requesting additional funding for cross-cultural assistance but never received it. What is the job description of a cultural assistant? There are 3 models which vary greatly. I think one of them, optimum models, optimum for assistants. They're working with a single school every day for a number of hours, or they are working with selected classes, grades 1 to 3, So sometimes assistants are attending history or biology classes wherever they are most needed. What all models share in common, assistants are cooperating very closely with teachers and they are very close to children. Sometimes they are sitting right next to the child while classes continue to explain or even interpret for them while classes continue. They are available during breaks, so it's fair to say that they are the part and parcel of the school community. Sometimes there is a single assistant working at several schools. Why? Usually because of insufficient budgets. An NGO has a budget to hire a single assistant, and this assistant is working with several schools to support more children. This is not the best solution, but this is what we see very often.
Now let's look at the actual job responsibilities and the results of the work. They're mainly seen as translators or interpreters. Really, they help interpret the tasks, the school instruction, or the comments made by other parents and teachers. They help children learn Polish, which is not the core task. They are not supposed to be the teachers of Polish. There are other teachers who are in fact responsible for that. They also liaise between the child and the family and the community, and they take away the burden from schools in a number of other areas as well. They explain cultural differences. They help solve and resolve conflicts, and they intervene when there's any sign of discrimination against children on the grounds, ethnicity or language. They help understand culture and help understand the requirements of the Polish educational system. That applies to both children and their parents, of course. And they are the role models, a friendly adult at school that helps the child maneuver or navigate rather the new reality in a new country, in a new school. And again, liaison work. They sometimes took care of online classes with the teacher giving them instruction what part the teaching material they should cover. They were the first line of emotional mental support. That role could not be overestimated. The pandemic, by the way, was a period where assistants were massively laid off. In fact, the decision was absolutely wrong because assistants were in great demand at that time. Now, challenges and needs, let me try to convert them into recommendations. One challenge is that the number of assistants is insufficient in Polish schools. Some encouragement from government institutions responsible for education would certainly be more than welcome. In unstable employment, most of the assistants are employed for the school year from September to June. They don't have any jobs during the summer. That is not helping the sense of job stability. So again, some policy would be required to structure their employment and to make it more pertinent. Most often than not, their employment is based on short-term civil contracts. Um,
zatrudniani z puli środków administracyjnych? Czy nie ich wynagrodzenie idzie z tej
not,
puli, co wynagrodzenie pani sekretarki,
not enough,
pani i panów
not
woźnych,
enough
takiej kadry administracyjnej
funding
szkoły, w
for
związku z tym też nie
wages,
ma takiej możliwości awansu
because most of the
związanego z
budgets,
podwyższaniem wynagrodzenia.
most of the time budgets for for ancillary staff, for janitors, cleaning teams is used as all from which wages to assistants are funded, and assistants are not included in the group that is covered by the teachers' charter, which is a set of privileges because their skills are not technically compliant. Even though the work is actually the actual work time is often much higher. Time exposure is one of the factors as well. Low prestige, low position in the school community. Let me give you two examples that will illustrate. One, I remember a school where an assistant was employed, and for the first 2 months, she couldn't get a key for the lavatory for personnel. She used the toilets for children, and this was quite telling. And the second example, during winter holidays, one of the principals had this idea of asking the assistant to clean the windows and floors during the winter recess when there are no children. Now the perception has been improving, the role has been more and more appreciated. The role is gained more visibility, and there's much more appreciation. But still, there are issues with this, and lack of access to professional development. Mikołaj will tell you about a postgraduate course that's one of the responses. Right, so because of time pressure, let me jump over certain things. Over the past 18 months, assistants have become to be perceived as only working not only for children from Ukraine, children of other origin require such support. Schools have come to appreciate the role of assistants, therefore it actually the idea extends to children from other minorities. Finally, we would like to show one of the responses, one of the recommendations rather from our institute. We decided to suggest this course, intercultural assistant studies, for students and for faculty. The course was put together very soon, right after a major wave of refugees made it to Poland. Who are those who take interest in the academic course and what countries they come from? You're looking at spam. By the way, this is not English spam. This is it's a working name for the cause. We're happy with it. We are terribly happy with it. We're going to spam Polish schools with people. That's what we tend to say. It's totally irrelevant. But anyway, the course has been growing. We're nearing the level of 70 graduates at the moment. So we are contributing to the emergence of another professional group. And this course is not, and I emphasize, not provided online. It's about physical interaction, personal interaction, and learning the sense of agency and being together. The majority of students are Ukrainian nationals, but we have we've had nationals of Belarus, Vietnam, Russia, Kazakhstan, Tajikistan, Iran. These are the sort of these are the types of these are the nationalities present as minorities in Poland. Some of the assistants lost their jobs recently because there's been less interest, even though there's much more buzz around this.
Mamy to szczęście właśnie, że dzięki zainteresowaniu międzynarodowej opinii publicznej możemy te studia umożliwić uczestnictwo w nich za darmo.
We're fortunate enough to have international interest. We have received funding from Norwegian Refugee Council, so this is why our course is free of charge. Now, this story is not just for us to boast. We wanted to place it in a broader social context. The foundation of the social diversity and a coalition of various charities who used to employ cultural assistants, and they had created a community, decided to contribute to the establishment of our cause, this has been instrumental because not only theoretical, but also practical experience with teaching is pivotal. So we started the course in October 2022, and let's look at the photographs. These are graduates of ladies who work in Polish schools. Before I say thank you for your attention, I would like to share the third mission with you. And this is about a relationship between academia and a community of professionals and broader general public. We're trying to reach out using media, press, radio alike. Currently, we attach great hopes to a new philosophy of the education ministry in this country, and there will be much more openness to supporting such initiatives. And the new minister is about to receive a package of information materials from us about the course. Hopefully, she will read it and give us support. Thank you. I'm getting looks from Andrzej Kasiło. The most important thing is that interpreters must leave us at 5:30. We are terribly appreciative of that, and we'll make it with time. We promise. The last speaker is great friend Ludmila Dubczak from the Forensic Analysis Center. And Dr. Dubczak is going to tell us about children at the time of war and challenges for Poland and other countries of Europe. 20 minutes. Be disciplined, please. Good afternoon, ladies and gentlemen, dear organizers. Thank you for inviting me, and thank you for giving me an opportunity to present a paper on children from Ukrainian homes, meaning orphanages at the time of war, and we'll talk about challenges for Poland and other European countries. I'll try to be very brief. There's a large number of children which are being evacuated from Ukraine on a daily basis. We are hoping that their homes, their institutions will be rebuilt so that we can return them home. And here, a big thank you to all who have been helping us, both outside of our country and in. Anyway, I'm supposed to focus on institutionalized children. Let me start with general statistics, and then I'll move to the discussion of institutionalized children. We have no exact statistics of children in care in Ukraine. We understand that about 40% of all children who left Ukraine are children and young people up to 18 years of age, about 3 million individuals, give or take. In 2022, there were more than 2,000 students in schools, 180 in Poland alone. We can compare it against statistics before the 24th of February, up to 1.5 million children, that's the total number, who were in Poland after the 24th of February. That comes from a report which was published in 2023 in November. That was about 1.7 million. And we have statistics of children who went to school, and we need to compare the numbers, and we have to conclude that nobody had been prepared for those numbers.
So after the 24th of February, the number of Ukrainian children at primary school has doubled. So it's very easy to imagine how many more teachers and educators were required to make it work. We need to focus on all children because this situation has presented problems for all of them. And there were also unattended minors, children who were separated from their parents, who stayed behind in Ukraine. And later, I will tell you that separated children who were transferred into the care of other people were given the status of children with guardians in other states, but not in Poland. According to data of the EU, in 23 EU states, there were 23,000 such people altogether, so unattended minors and children who arrived in groups from children's homes. What was happening in Poland at the time? Well, data vary because we had very different figures for different European countries, which were obviously inaccurate. So where do reliable data come from? Well, the number of Polish registration numbers issued to Ukrainian children, 27% of applicants were children and youth under the age of 18. So the number of registrations suggests that total number of children, of minors, including unattended minors and children from orphanages, accounted for a very large group. It's several dozen thousands of children. Polish courts were also issuing decisions on temporary custody or foster relationship, because when unattended minors were arriving in Poland, they were given into custody of relatives or acquaintances of their families. So there is a huge difference between the status of youths applicable to children under the age of 16 and 18. For example, in Ukraine, since the beginning of the war, it was impossible to control who is leaving the country. And in addition, Ukrainian regulations allow children aged from 18 to 16 to leave the country unattended. They don't need to get a permission of Ukrainian authorities. For example, in Poland and in Germany, I know that things are very different, but as you know, in Poland, Italy, in Germany, youths aged from 16 to 18 are detained and they are transferred to specialist institutions for unattended minors. So when the war flared open in February 2022, when everyone was leaving the country, children from institutions were evacuated to different countries. From eastern Ukraine, they were usually heading for Poland, Germany, and Romania. But there are also children who were relocated from less risky regions of Ukraine. For example, Transcarpathia from the Lviv Oblast, from Zaporozhye, they were also relocated outside Ukraine. Now, children from different institutions or children's homes in Ukraine, the number of evacuated children from such institutions total 6,200. Some of them were displaced in Ukraine, but more than 3,000 were taken abroad to other countries. And we do know that there were problems related to their displacement. We hear about problems because their status is not regulated in different countries. We have very different systems and regulations in Ukraine, in Poland and other states. And this is something I'm going to discuss. In Ukrainian orphanages, there are children with at least one parent, very often two parents. And orphans account for more than 3,000. And out of orphans, 2,000 children were evacuated overseas. As the number of facilities we have in Ukraine, 214 have been evacuated, and 168 orphanages have been evacuated overseas. So data may vary over time, but out of 727 orphanages in Ukraine, 168 were evacuated overseas. So these are data I had when I started my research. And now about the difference between facilities based in Ukraine and overseas. In Ukraine, we have data on the percentage of children who are living in orphanages. It's 1.4%. In Austria, it's 0.1% and 0.5% in Poland or Bulgaria. And of course, the system we have in Ukraine had to be reformed, and the reform started some time ago. And many countries have abandoned the system we have in Ukraine. For example, in the US, this system has been reformed a long time ago. In the UK, after the end of the Second World War, the reform was introduced. In the UK and Northern Ireland, in Norway and in Iceland, there are no such facilities for children under the age of 3, and we have them in Ukraine. So the difference refers to rules, the organization and procedures. How are children sent to such orphanages? We know that 81% of children are placed in such facilities by parents. This is something we don't see in Poland. So it's not only a court procedure, but also an administrative procedure that enables children to be sent to orphanages. There are also boarding schools in Ukraine for children with different types of diseases, with diabetes, with TB. There are facilities like this. Well, data I've been using state that Poland is not home to such facilities for children with mental diseases, autism. There are separate facilities for such children. So the problem is how to regulate evacuation, how to regulate migration, because there is a huge difference in such system, and countries, host countries, are doing their best to protect human rights. They are protecting rights of children. Children from that country and those who have been evacuated there. Our system in Ukraine was being reformed. This reform started in 2017, and as you can see on the table, it was supposed to be completed by 2026. So to transition from those huge facilities, because there are children's homes with 200 to 300 children. You don't have such facilities anymore in Poland. At the beginning of the reform, there were around 700 facilities. And after the reform, we had to achieve the figure of 0.5% of children living in orphanages. So we wanted to have facilities with less than 10 children, but the war has decelerated this process or even has put it to a halt. right now it's not able to continue the reform. Those facilities report to different ministries, the Ministry of Health, Education and Social Policy. And there are also different categories of children up to the age of 3. Those facilities report to the Ministry of Health. Others report to the Ministry of Education. Of course, the system was to be reformed. And now the war, which started not on the 24th of February, but much earlier, but from February last year, you can see on this slide information from Kharkiv district about evacuation of children with very serious conditions. Those children had very different difficulties, and he stated that on the border, officials did not believe on the Polish border that he's evacuating children with serious conditions. And he was explaining that one of the children, who was 4.5 years old, had very serious conditions and looked 3, was actually the child that was declared in documents. The Ministry of Social Policy asked 23 countries to sign a memorandum. I know that Poland and Lithuania have signed such memoranda. And as we know, every country wants to protect its interests. So a political declaration was made with Poland. And this document regulated many issues. Enormous assistance was provided by Poland. As you can see, in October 2023, a house for Ukrainian children was purchased, and right now it is home to 14 children from Ukraine and Poland. It was sponsored by philanthropists from different countries, but it was a Polish initiative. Okay, so what are the problems that we face and why? There are different approaches to placing children who were evacuated from Ukraine in orphanages in Europe. There was one approach to keep the group as it left the Ukraine. For example, if a group of 90 children was leaving Ukraine, they should be kept together. There was also a different approach resulting from the reform. Children were placed and dispatched to different families to make sure that one family is looking after 1 or 2 children. For example, in Italy, 24 Ukrainian children were sent to Italy, and custody rights of carers were not recognized in Italy. Children were distributed to different families, which gave the Ukrainian children back, and children were eventually placed in Italian children's homes. Why? Because in Ukraine, in such children's homes, it's the principal and the carer, which are legal guardians, and their status has not been recognized in Europe. So this is due to differences in regulations. There were also cases in Italy when groups evacuated from Ukraine were sent to a single facility. For example, a group of 93 children aged from 8 to 18. They were hosted by a small municipality, and a court decided that this group should be kept intact. Well, children are often taken away because parents are not fit as carers, and European countries are making sure that children are looked after. Otherwise, they are taken away. It's a very stringent position of states, especially in the Scandinavian countries. In Scandinavia, for example, in Sweden alone, there were 5 cases when children were taken away from Ukrainian families. And in Poland, I read an article in the press and an article in Ukrainian press. It covered the story of a family that left Mariupol. They had 11 children, 8 were adopted, 3 were biological children, and children were taken away from them in Poland, in Wrocław, by decision of a court. I think children were sent to Polish carers, but a court issued a decision. We also know of other cases. For example, there was an article about a very doubtful situation in Kazimierz Dolny. A Ukrainian family arrived there with foster children, and this group was looked after not only by Ukrainian carer, but also a U.S. carer, minister from a U.S. organization. Who had a contract with this family. He was accused of preparing children for adoption in the U.S. This case was publicized in Poland and reported to the authorities, and a Polish and Ukrainian carer could not leave the country. I don't know what happened to those children, but the Consul General of Ukraine sent those children to Switzerland. So it looks like those carers eventually did what they intended to from the beginning. So this poses challenges to the state. An act which was adopted regulated many issues. This act was adopted on the 12th of March 2022. The act changed a lot in the legal framework. Children were leaving Ukraine, but the act mitigated the risk of children trafficking, of illegal adoption, so a special policy was put in place to prevent that. Thank you very much. Thank you very, very much. Well, I said that we need to discuss those issues. We can talk about it very fast, but we need to talk about it. Thank you very much. Okay, so are we leaving the table and you are going to finish the conference? Well, we need to have a discussion, at least one question. Okay, let's give us another minute or two. Okay, one question. My name is Wieczysław Gienatowczyk. I'm a psychotherapist from Ukraine. I wanted to talk about assistance because I work as a mobile psychologist in school. I work for a foundation and we are supporting Ukrainian children. We are collaborating with psychologists, with schools, with educators, but this system is not enough. All problems are borne by assistants. Psychologists, school psychologists don't speak Ukrainian. They are not familiar with Ukrainian culture, and there is one psychologist per 100 children. But perhaps funds should be earmarked to support assistants. There is a lot of burnout. People don't want to work. We have to deal with all sorts of problems that arise in schools. There are cases of bullying. There is a lot of misunderstanding. There are xenophobic behaviors. There are many situations like that. We are funded by the Office for Education and Bloomberg. And last year, there were 100 hours of psychological support. For example, I was supporting 25 schools. This year, I'm supporting only 5. And that's important. We cannot miss this aspect. Assistants need to be supported, otherwise there will be a lot of burnout. Thank you very much. Well, thank you very much for addressing this issue, because cross-cultural assistants, just like all other professions, should have access to supervision, and some assistants have access to supervision provided by NGOs, and they claim it's invaluable. And I think roughly 18 years ago, assistants from NGOs and schools came up with an idea to split this role or create a new position of cross-cultural psychologist or educator. This person could be employed by the school just like psychologists are, but have a cross-cultural specialty and migration experience in migration. Of course, you need to have psychological background. So ideas like this are coming up, and I hope they will come to fruition. To make sure that those cross-cultural assistants of psychologists should be accountable to, not to the school principal, but to an authority, because you cannot put pressure on cross-cultural psychologists, especially the school principal cannot put pressure, because there were situations like that, that all problems should be kept at home. Okay, well then, I can close the conference. Thank you very much to all of you for keeping the time for very interesting topics that you brought up, for combining practice with theory. And over to Andrzej Kosyło, who will let us go home. I don't know. Opinions vary. I would like to thank everyone who stayed with us until the end. I know that we had very tight schedule, so a big thank you to all of you. I would like to thank our speakers, especially guests who have come here from very different parts of the world and who have enabled us to create a platform that will be developing. I would like to thank all partners of our conference, and I expect that contacts we have made today, that the knowledge we have received today, that everything will be used in the future. There will be publications released from this conference, so I would like to thank everyone, and probably in the future, in not so distant future, we will come together again during another event, and I expect that those events will be dedicated to taking stock of Russian crimes and not only contemplating how to do that, how to bring perpetrators to justice. Thank you very much.